Wait, please, Lordship. Item number 7 and 9 may can be adjourned for the day, Lordship.
No,
Engage counsel
without,
of station.
whatever be the good reason, but on Tuesdays and Thursdays, if you don't take give us prior intimation, we are not adjourning any matter.
It is out of station, Lordship.
We can't help it. You got the list yesterday. Yesterday you could have told the court master. You would not have gone through the file.
It's mother's illness, Lordship. Is out.
We can't help it.
Yesterday, yes,
I've been telling daily, day in and day out, that on Tuesdays and Thursdays, no adjournment without prior intimation. So I'm sorry. Yes.
Lordship, I had a prayer for item number 6. In fact, Lordship, this matter was taken up by your Lordship and Honorable Justice Arda Kette. Previous, huh?
The scanned copy of the KDRI is available.
Yes, Lordship, and I think Lordship, it was parted for that bit. Lordship, I have got some personal difficulty today, and perhaps this bench will not also take up because it was heard at length by your Lordship.
I'm not getting it. Please repeat again.
This matter was taken up by your Lordship and Honorable Justice Arda Kette. It was heard for maybe 2 or 3 days, Lordship.
Yes.
So
Okay. Oh, I thought this was this bench. Okay.
it was not in this bench.
Okay.
And on the other side, Lordship, I've got some personal difficulty today. If it can be on any other day, Lordship.
Just one. Item 6. Let me go through the, because I did not check the constitution of bench. As and when the bench is available.
So nice.
Okay. Both sides are represented. As the matter is a parted matter, with the bench of one of us, with the K.R. Suraji, and Mr. Kadagate, Ji, the registry shall list the matter before the said bench as and when available.
So best.
Most probably. This order be brought to the notice of the registry.
But it can be on 14th minor because it's all pending matter minor.
No, we understand, but it has to be the same bench.
Minor.
It will go to the Chief Justice and then it will come to the bench. As and when available, I have said.
Minor. Oh, bless.
Yeah, please, Lordship. With the consent from the other side, I would like to mention item number 1 for adjournment.
It's a motion matter.
Yes, sir.
Okay. Oh, yes, there's an adjournment slip here. Okay. Both sides are represented on the prayer made by Mr. I. Chakma. Right?
Yes, sir.
Learned counsel for the petitioner on the matter stands adjourned today. List after
3 weeks.
3 weeks.
Item 2 for motion.
Please, Lordship, the contested case, Lordships. The only
What is
ground,
the, which page is the opinion and the date of opinion?
it's 64, Lordship.
54. And what is the
64,
date?
64, Lordship.
64. And what is the date of opinion?
10/8/2023.
10/8/24.
The
23.
23. The petition is the widow Lordship, the very poor
It will
lady
23,
Lordships.
but 23 you'll have to wait for some time for bail.
Lordship, the very poor Lordship,
No, we understand, but
the financial condition is very bad, Lordship.
we
Only ground is
have to-
that, Lordship, the 70 to 85. This border list is not submitted, Lordship.
That's okay, but as a thumb rule, we are not granting bail for delayed approach to the court.
Lord.
Heard Mr. Ayan Ahmed, counsel for the petitioner. All the respondents are there. Ms. Bedi on behalf of Ms. P. Barwa. Opinion is at page 64. Opinion dated 10/8/2023. Passed by so-and-so in so-and-so, declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice extra copies within, give a date, returnable date after 4 weeks. Returnable on so-and-so, extra copies within 2 days. Prayer for bail shall, let the records, relevant records be called for from the concerned tribunal. Prayer for bail shall be considered on receipt of the records of the tribunal. List on so-and-so.
9th of June.
9th of
June.
ten, Lord.
Hmm?
10.
20 on 10th. 10th is a Tuesday, then take it 11th.
Lordship.
11th.
In motion column, Lordship.
No motion column. We should notice. It will come in admission.
Admission.
11/6.
Biplab.
Three episode. The time has said. Yes, item 3. Yes. Last time we had taken an adjournment to address us.
Yes. Lord.
My lord, my humble submission is that Lordship, there is no infirmity in the opinion, Lord, passed by the learned tribunal. And reason order has been passed, Lordship, by the learned tribunal. And Lordship, proceeding totally failed. Lord. Proceeding totally failed to establish her link with her projected father. Lordship. Lordship, they relied on exhibit C, Lordship, final Khotian Lordship. Page 22 of the repetition, Lordship.
Yes.
Yes, Lordship. Here, Lordship. One check Ainullah is reflected, Lordship. Son of late Jamirullah. And it is a Toziland, Lordship. Toziland, Lordship. But this same time, Lordship, they relied on a voter list of 1966, Lordship, as exhibit A, Lordship. Here one Ainullah Munsi's name is reflected, Lordship, is at about 41 years, and the related person's name was reflected as Gamiruddin, not Lordship, Jamirullah, Lordship.
This certain minor discrepancies has to be omitted.
Lordship. That's true, Lordship, but Lordship, I think
You,
Lordship,
you are referring to which entry?
1966 Lordship,
Voter list.
voter list. Ainullah Munshi, projected grandfather Lordship. And son of Gamiruddin.
Yes.
Yes. Okay. Then Lordship, 1977 voter list, they are relying as Exhibit B Lordship. Then after that Lordship, there is no other voter list has been projected up to 1997 Lordship. So Lordship, continuity is not there Lordship. And Lordship, another exhibit land document Lordship, annual Khirat Patta, exhibit D Lordship. Here also,
But when you are referring to this page 1966 voter list,
Lordship,
the polling station in 1966 and 70 is same.
yes Lordship. But
Who's Sopiur Rahman?
Sofiur Rahman is the projected father.
Father.
Yes, Lordship. And Lordship, next Lordship, exhibit D is the periodic Kheras Patta, although in the top so many names are reflected, but Lordship, in serial number 1 Lordship, it was, if Patta was only in respect of Porichek, Pita someone Jamir Lordship. So by this document Lordship, Protiti cannot establish her link with her projected father Lordship, Sofiur Rahman. And Lordship, most important document Lordship here to establish our link is Lordship school certificate, page 19 Lordship. And this is the only link between the Proceedy and her projected father. And death certificate was rejected because state emblem was embossed at the top of the certificate Lordship. So Lordship, and this was issued in the year of 2014, whereas Proceedy left the school in the year of 1992. Lordship, in the present case, Lordship, link between,
Just a moment.
yes, Lordship.
Mr. Barbia,
Lorships.
is the date of death of your grandfather available?
Grandfather's date of death not available.
Okay, approximate year. His last voter list is 1970.
Lordship.
After that, he's not there. Because then the grandmother says Beva.
Beva.
That means
Widow.
that
Widow.
means he would have died.
Lordship.
Mr. Barbia,
Lordship.
we have a query for you. You see, please come to page 29 and 30. First of all, 728. Page 28, the name of your grandfather, projected grandfather is Ainullah Munsi,
Lordship.
son of Gamiruddin.
Gamiruddin.
Grandmother's name is Moina Bibi Ainullah Munshi. Correct. Now please come to 2930. This is 2930 is voter list of 1977. Now, Sopio Rahman is your projected father. And Moina Beva, that
Step
means your
grandfather.
grandfather would have died in sometime before 1977. Correct.
Since two persons' name here appeared, Lordship, even I can't say.
No, we
that-
understand. We are just looking at this
Since
entry and we are
full-
presuming.
Since full
we are-
voter list is not here,
no, it's okay. From this entry of Moina Beva,
Lordship.
we understand that
He,
she
is my
she's
step
a widowed
grandmother.
lady.
She is my.
No, it's
yes,
okay.
Beva
She's a
is
widowed lady.
Yes, yes.
She's a widowed lady.
Beva widow, Lordship.
Yes. Now please come to page 25.
Periodic Kiras Patta.
Yes. It is in whose name? Serial number 2 is
Ainullah is my grandfather, Lordship.
grandfather.
Lordship.
And you see, come to down point number 1, 2009 sonor. So that means 2009 your grandfather was there. You are bringing some other documents.
No, actually, Lordship, issued on 2009, Lordship.
I understand, but you see, it's a Miyadi Patta. If it is issued, the man has to be alive. 77 dead percent dead in 1977 will not get a patta in 2009. 30 years down the line. 32 years, in fact.
May not be corrected the land records, Lordship, it was earlier documents.
No, that is something we are not aware. We have no personal knowledge of it. We are going through your documents.
This Pita Jamir.
And it doesn't say that it's a renewal of the patta.
I think Lordship, as per his document, Lordship, Jamirullah died prior to 1962, Lordship. Page 22, Lordship.
Who died?
Jamirullah, this Lordship,
Page number?
we check Pita Jamiri, this Jamir Lordship, her great grandparent, Lordship. Page
No,
20
we are not on that.
Yes, sir.
Second name here is Ainullah. Ainullah, this pata is issued in 2009.
Yes.
Okay. Mr. Sharma, what else you are saying?
Lordship. Lordship, regarding continuous stay, Lordship, I want to rely on a decision of this court, Lordship. WPC 775 of 2024
On what point?
regarding continuous stay, Lordship.
Name of the parties?
Sukjan, SUKJAN, NESSA, NESSA, NESSA. Lordship.
Registration number WPC
WPC 775
of
2024
decided on
decided on Lordship 17 to 2024. Para 13 as well as Lordship Para
1313.
13 Lordship as well as Para 26.
23.
26 Lordship. Para 13 may I read Lordship?
Yes.
In the case of Monoduti Nandi Supra, the requirement of continuous stay has been emphasized so as to meet the requirement of establishing citizenship. In this case, there is a long gap from 1970 to 1985 with regard to the voter list of the projected father. We have perused the provisions of section 683, which is as follows. Subject to the provisions of subsection 6 and 7, every person of Indian origin who came to Assam on or after 1st day of January 1966, but before the 25th day of March 1971 from the specified territory and has since the date of his entry into Assam has been ordinary resident in Assam and has been detected to be a foreigner shall register himself in accordance with the rules made by the central government in this behalf under section 18 with such authority as may be specified in such rules, and if his name is included in any electoral roll for any assembly or parliamentary constituency in force on the date of such detection, his name shall be deleted therefrom. Explanation: in the case of every person seeking registration under this subsection, the opinion of the tribunal constituted under the Foreigners Tribunals Order 1964 holding such person to be a foreigner shall be deemed to be sufficient proof of the requirement under clause C of this subsection, and if any question arises as to whether such person complies with any other requirement under this subsection, the registering authority shall, if such opinion contains a finding with respect to such other requirement, decide the question in conformity with such finding. If such opinion does not contain a finding with respect to such other requirement, refer the question to a tribunal constituted under the said order has jurisdiction in accordance with such rules as the central government may make in this behalf under section 18 and decide the question in conformity with the opinion received on such reference. The requirement of registering with the Foreigners Registration Authority under section 683 of the Citizenship Act is subject to the following conditions precedent: that the president came to that the proceedee came to Assam after 1/1/1966 but before 25/3/1971 and since the date of his entry into Assam been ordinarily resident in Assam has been detected to be a foreigner. In the instant case, as per the order of the tribunal dated 16/6/1993 is taken note of that there is no finding of fact that since the date of their entry into Assam, the petitioners had ordinarily been residing in Assam. The only finding arrived is that the petitioners have entered India between 1966 and 25/3/1971. As the requirement of the conditions precedent of section 683 had not been fulfilled in the case of the petitioners as revealed from the order of the tribunal, we are of the view that there is a requirement of law arrive at a finding of fact that the petitioners have ordinarily been residing in Assam since the date of their entry. Then Lordship, para 26, I am relying, this court finds in force in the contention of learned standing counsel who has cited the case laws Tutamia, Supra, Borhan Ali and Munuduti Nandi with regard to the procedure to be followed for proving voter list as well as of the aspect of requirement of
But,
continuous stay.
no, but this is 6A3.
Yes, Lordship.
6A3 is only for, what you call,
This is regarding registration, Lordship.
registration. It's not applicable here.
6A2 is clearly states that, Lordship, there must be continuous stay, Lordship. I mean, 6A3 is regarding registration, but this case was emphasized on continuous stay.
But the language is under 6A2 and who have been ordinarily resident of Assam since the date of their entry into Assam.
Yes, Lordship. Then, Lordship, regarding regarding inquiry, Lordship has decided, Lordship, regarding LVO inquiry, Lordship.
What did you last say? I missed it out.
Lordship, regarding LVO
LVO report.
Yes, Lordship. And Lordship has elaborately discussed in a repetition, Lordship, WPC 245 of 2019, Lordship.
WBC
245 of 2019, and earlier occasion, my colleague has cited Amina Khatun's case, Lordship, and that was distinguished in this case, Lordship.
is judgment dated.
Judgment dated, Lordship.
It was 2024, Supreme Court case.
28 to 2025.
Are you aware of the name of the parties?
Sukurjan Nesa, SHUKURJAN,
S.
SHUKURJAN,
SHU.
yes, Lordship. KURJAN, Sukurjan Nesa, alias Sukurjan, SUKURJAN.
Yes.
It was decided on, Lordship, with 28 to 2025.
Yes. Paragraphs.
Paragraph, Lordship. para 20 lordship may, however, in this case of Amina Khatun, which was decided on 28/4/2022, the reference was made by the superintendent. Para 20 lordship.
Yes. Yes.
Yes, lordship. And every aspect has been discussed, lordship. In this case, whole judgment is, lordship, very important, lordship. So here, and lordship, although lordship headmistress came before the tribunal to depose on behalf of the proceeding lordship, but lordship, nobody of her family members came before the tribunal to depose on behalf of her lordship, although mother is still alive, lordship. Lords. Hmm? Therefore, question. Into page 61 is the deposition, lordship, of headmistress, lordship. Apart from that, lordship, there is nothing to prove that, lordship, she is the daughter of, granddaughter of this Ainullah Munshi, lordship, whose name reflected in the year of 1966 voter list, lordship. And lordship, there is no link between the father and grandfather, lordship.
Just only.
Entry report to Pulsar. Entry report to Lordship. a- Apart from that, Lordship, page 62, may I read Lordship? Page 61, Lordship. Administrative evidence, Lordship. Lordship, administrative Lordship, evidence Lordship, page 61, Lordship. I am the headmistress of 214 number Belgui LP school, working since 1982. This school was provincialized in the year 1991. I received summon from the tribunal. Exhibit F certificate was issued by me in the name of Rafika Khatun, daughter of Sofiur Rahman, village Belguri Part 1, PS Agumoni. Exhibit F certificate was issued by me on 21/2014. Exhibit F1 is my signature. Rafika Khatun left the school on 31/12/1992, and she was uh, she was promoted to class 3. I have brought the counterfoil of the certificate. I have brought the admission register of the school. As per admission register, Rafika Khatun, daughter of Sofiur Rahman of village Belguri Part 1, Belguri, was admitted in the on 1/1/1991 in class 1, and as per admission register her age was 6 years, 6 years on 1/1/1991. And cross lordship Rafika Khatun is personally came to school for school certificate. I issued the certificate as per record. No countersign of BU was obtained. No written application was submitted. No permission was obtained by me prior to issuance of this certificate. That much only. And Lordship, projected herself, projected father's name is Lordship as per her statement, Lordship Sofiur Ali, Sofiur Rahman, and Sofiur Ali. And but not a single document has been placed that Lordship, this Sofiur Ali, Sofiur Rahman, Sofiur Rahman are same in one person, Lordship. That is one aspect, Lordship. And Lordship, apart from that, proceeded totally failed to prove the existence of her projected father prior to 1966. Or Lordship, proceeded also could not able to establish her link with her projected father to that of grandfather, Lordship. So there is a totally failure of link, Lordship. She wants to. কিন্তু অক্ষত খুব করে অক্ষত Lordship, regarding school certificate, Lordship, I want to rely on a decision of this honorable court, Lordship. WPC 7756 of 2016, Lordship. Where- 7756 of 2016.
Decided on
Decided on 26/4/2018.
name of the parties.
KHUDEJA, Deja. Khatun, KHATWN. Para 12, Lordship. I am relying, Lordship.
Yes, what does it say?
Exhibit A is a transfer certificate dated 9/1/2016 issued by the headmaster of Uttar Durabandhi Bill LP School certifying that Masammat Kudeja Khatun was the daughter of late Jonabali of Durabandhi Bill village under Moirabari police station in the district of Morigao. She had left the school on 31/12/1988 after passing class 2. As per admission register, her date of birth was 12/1/1981. This certificate cannot be accepted as a valid piece of evidence for more than one reason. Firstly, state emblem of India embossed in the certificate. The state emblem of India regulation of use rules 2007 has been framed by the central government in exercise of powers conferred by section 11 of the state emblem of India prohibition of Improper Use Act 2005. This act was enacted by Parliament to prohibit improper use of state emblem of India. Section 3 specifically prohibits improper use of state emblem. It says that notwithstanding anything contained in any other law for the time being in force, no person shall use the emblem or any colorable imitation thereof in any manner which tends to create an impression that it relates to the government or that it is an official document of the central government or the state government without the previous permission or authorization. Headmaster of LP school is not authorized to use state emblem of India in any manner. Such unauthorized use of state emblem of India has rendered Exhibit A inadmissible in evidence. Secondly, as per this certificate, petitioner had left the school on 31/12/1988. This certificate was issued 28 years thereafter on 9/1/2016. Such belated issuance would necessarily cast serious aspersion on the bona fides of such certificate, which is highlighted by the unauthorized use of state emblem of India date to not as per the statutory format. And thirdly, and most importantly, the author of the said certificate did not appear. But here, Lordship, I am omitting this part, Lordship. Here, author was examined, Lordship. Hmm? Hmm. And and Lordship, although school certificate was issued in the name of Lordship Sophia Rahman, Lordship, but Lordship, and that was issued as per record, but her most important document, Lordship, Gaon Panchat certificate, exhibit G, Lordship, page 41, Lordship. Here specifically stated that, Lordship, Rofika Bibi, daughter of Sofior Ali. This is her father's actual name, Lordship, Sofior Ali. Lordship, nowhere stated that, Lordship, Sofior Ali, Sofior Rahman, Sofiar Ali are same in one person, Lordship. And this Gaon Panchat secretary, although this document is not admissible in evidence, Lordship, but apart from that, this Gaon Panchat secretary never come before the tribunal to depose on behalf of her, Lordship.
That's all.
Yes, Lordship, earlier occasion, Lordship, learned colleague relied on Karim Malis and Motiur Rahman's case, Lordship, and in these two cases, Lordship, facts and circumstances is totally different from this case, Lordship. This is my humble submission, Lordship. And Lordship, under aspect, Lordship, I want to read few lines from our High Court judgment, Lordship. WPC 6128 of 2018.
On what point?
On regarding certiorari, Lordship. Where Lordship, Central Council for Research in Ayurvedic Science, Lordship, that judgment was quoted, Lordship. Para 17, Lordship.
No, what's which representation, name of the parties, date of judgment?
6128 of 2018.
6.
128,
Of
2018. Aitullah Paramanik. AITULLAH. PARAMANIK.
decided on
Decided on Lordship May 10/4/2024.
yes.
Para 17 Lordship. Law is well settled in this field. The Honorable Supreme Court, after discussing the previous case laws on jurisdiction of a writ court, qua the writ of certiorari in recent decision of Central Council for Research in Ayurvedic Science and another versus Bikaton Das and others civil appeal number 3339 of 2023 has laid down as follows. Para 49, before we close this matter, we would like to observe something important in the aforesaid context. Two cardinal principles of law governing exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to issue of writ of certiorari. The first cardinal principle of law that governs the exercise of extraordinary jurisdiction under Article 226 of the Constitution, more particularly when it comes to the issue of a writ of certiorari, is that in granting such a writ, the High Court does not exercise the powers of appellate tribunal. It does not review or reweigh the evidence upon which the determination of the inferior tribunal purports to be based. It demolishes the order which it considers to be without jurisdiction or palpably erroneous, but does not substitute its own views for those of the inferior tribunal. The writ of certiorari can be issued if an error of law is apparent on the face of the record. A writ of certiorari, being a high prerogative writ, should not be issued on mere asking. The second cardinal principle of exercise of extraordinary jurisdiction under Article 226 of the Constitution is that in a given case, even if some action or order challenged in the writ petition is found to be illegal and invalid, the High Court, while exercising its extraordinary jurisdiction thereunder, can refuse to upset it with a view to doing the substantial justice between the parties. Article 226 of the Constitution grants an extraordinary remedy, which is essentially discretionary, although founded on legal injury. It is perfectly open for the writ court exercising this flexible power to pass such orders as public interest dictates and equity projects. The legal formulations cannot be divorced from the realities of the fact situation of the case. While administering the law, it is to be tempered with equity, and if the equitable situation demands after setting right the legal formulation.
This we have already considered earlier.
Yes, Lordship.
You
Yes,
cannot did.
yes, yes.
This was paragraph
Para 17, Lordship.
17.
If required, Lordship, this judgment can also provide, Lordship.
That's all, Mr. Borbe, anything in reply?
May I please, your lordships, my learned friend now developed the case. This is not a case before the tribunal. Whatever submission made, everything is a new case. And lordship will find of my WS page 43. Lordship got it.
Yes.
Page 43, the WS, paragraph 4, lordship. Last occasions, I read about this paragraph, lordship, regarding very initiation of the case. No enquiry, nothing else, never
Yes.
visited. The instant case has been registered and proceeded against the opposite party illegally, and the border police, Dubri or LBO, did not make any field visit during investigation, never asked the opposite to produce documents in support of our citizenship. never interrogate the opposite party in presence of village heads, and the case has been falsely referred against the opposite party without giving any opportunity to demonstrate that the opposite party is a citizen of India. Thus, there was no fair investigation, and without fair investigation, there cannot be any fair trial. Then, regarding my learned friend also stated that I have not clarified my father's name. Also, that is also in paragraph 5 regarding whole family tree, I have given lordships. Paragraph page 44, paragraph 5 in my WS lordships. That the opposite party was born and brought up in the locality of village so and so, so and so. She is the daughter of Safir Ali, Safir Rahman, Safir Ali, father, that times alive lordships, and Zainab Bibi mother alive, who are Indian citizens. Her grandparents' names are Ainullah Munshi grandfather since disease, and Sabijan Bibi grandmother since disease, Moina Bewa stairs grandmother since disease. The opposite fathers are 4 brothers, 2 sisters, including opposite party's father, namely Safir Ali, Safir Rahman, Safiyar Ali, opposite father, Mujibur Rahman, Ali Hussain, Abdul Hussain, Anwara Bibi, and Rabia Bewa since disease. The opposite parties are 1 brother and 1 sister, including opposite party, namely Rafika Bibi, alias Rafika Khatun, opposite herself. The Jaimuddin Sheikh, opposite party, is a married woman. She has her husband Karim Baksh Sheikh and 3 sons, 1 daughter, namely so and so, so and so. Then lordships, details family, my father's name also clarified, lordships, paragraph 15, page 46. My learned friend said there is no clarification in my father's name, Safir Ali or Safir Ahmad. That paragraph 15, lordship file, page 46. That opposite party's name in variation has been recorded as Rafika Khatun in her school certificate and Rafika Bibi in the voter list on 7, 10, and 15 and GP certificate, and both the names are same and one identical person, that is opposite party herself. The opposite father's name in variation has been recorded.
Just a moment. You know why we are smiling? You once you read it,
Lordship.
we are also reading it with you. Although it may appear to you that we are perhaps not concentrating on your submissions, that's not so. Please come to page 55.
Affidavit, DW2.
Yes. His name is Mohiuddin Ahmed, alias Mohiruddin Sheikh,
Yes,
right?
Lordship.
He is your uncle,
Yes,
correct?
Lordship.
Then you should not have read page 44. You should not have read page 44.
He is my uncle, Lordships.
We understand.
Yes, Lordship. I am clarifying. Lordships. He is
Yes.
my grandfather's brother's son. That is in exhibit D, Lordship, the page 20, Lordship will find. For its sake, his name is
No,
there.
but the family is not there. You
There
said
he-
that she has described the
its
family,
sake,
but
Mohiuddin's father's name is Farisha, and both are the brothers. Ainullah is my grandfather. Sons of Jamirullah. Next page, Lordship will
no,
find.
but the evidence, then you see the evidence of DW2 is a improvement on your affidavit. You don't say that your grandfather had brother.
But document
No, this is
says
okay.
Lordship.
We are not questioning that document or anything else. But what we are trying to ask you is that the proceeding did not describe or introduce DW2 as her relative. So this DW2 comes and says that I am the uncle. We are only on that.
That has not questioned in the tribunal, Lordship.
No, it's not a question of.
Yes, Lordship, whether family member, yes, Lordship says questioning me, he is a family member, but documentary evidence says he is a family member. Although not necessary, but document cannot lie, Lordship. Document says, though, yes, I have mistake, I have not stated, but document says he is a family member. That has to be considered. And Lordship, kindly see my,
Which is that document which says that he is a family member? Which document?
there's Lordship, Exhibit C,
Exhibit C.
Lordship.
Exhibit C is the final
Final
Khatiyan.
Fatian. That documents my grandfather's name appeared. My grandfather's brother's name appeared. Great grandfather name is Jamirullah.
Which page?
Lordship's page 22 is the vernacular Lordship, and type copy is page 20.
Page 22, yes.
That document dated 30/1962. That was. Lordship, then page 53, Lordships. Cross part of the petitioner. Procedural, Lordship. My father, Lordship, got it.
Yes.
Page 53. This is the cross part of the procedural, Lordships. My father died about 2.5 years, half months ago, and my mother is alive. My father died at Belguri Part 1, and my mother is still residing at Belguri Part 1 with my brother. Joimuddin. I was born at Belguri Part 1. I got married with Karim Box of Uttar Kasakhana, and I have been residing with my husbands at Uttar Kasakhana. My grandfather's name is Ainullah Munshi. Grandmother's name is Moina and Sobijan Bibi. My grandfather's name entered in the voter list of 1966. Grandfather's name entered in the voter list of 1970. And my father's name entered in the voter list 1977 with my grandmother. Nothing denial, Lordship. They have not question regarding there is even no suggestions also. And in respect of DW2 Lordships, cross part, page 58. Page 58, Lordships.
Page
Page 58.
68.
58, Lordship. 58.
58.
58. Typed copy. Next page is the Lordship handwritten. Lordship got it.
Yes.
I was born at village Belguri, Part 1. I was born on 1/4/1948. Opposite party's father's name is Safir Rahman of village Belguri, Part 1. Safir Rahman died on 31/5/2019 at Belguri, Part 1. Mother of the opposite party is residing with her son Joimuddin at Belguri, Part 1. The name of grandfather of the opposite party is Ainullah Munshi. My name entered in the voter list of 1970. I am a regular voter. Grandfather of the opposite party, is Ainullah Munshi, was my uncle. Opposite party got married with Karim Box of Uttar Khasam. Then headmistress Lordship regarding school certificates she issued to the petitioner. That is page 60, Lordship. DW3.
Yes.
Page 60. Second paragraph, Lordship. It will be first paragraph, Lordship. Essay. I am the headmistress of so-and-so number Belguri LP School, working since 1982. The school was provincialized in the year 1991. I have
We have seen that
Yes.
the only objection here is that the school certificate has the state emblem.
Yeah, that is Lordship. And Lordships, in the impugned judgment, Lordships may kindly be looked in this page.
So that you have read,
That-
you have read, we have extensively marked in our copy.
Lordship, regarding no challenge, no findings at all in respect of exhibited documents A, B, C, D, and even brutal exhibit E. Only findings I find in the link certificate is there is a state emblem. That's why not considered. But there is no findings at all in my exhibited document, or there is no finding at all about my oral evidence. In this regard, Lordship, last occasion I have placed some decisions regarding oral evidence and document evidence, Lordships. That was last occasion I have placed. Lordship.
Yes, you have given us
Yes,
Rahim Ali.
Lordships.
You've also given us Motiur Rahman,
Batiur Rahman,
Karim Ali,
Karim Ali, Lordships,
and Abdul Khalik.
Abdul Khalid. And regarding very initiation of the case, Lordship, I have placed the discharge to the Honorable Affairs Public blank inquiry that was in special lead petition number so-and-so, ID number 206741 copy. That's last one for place, Lordship, before you. That paragraph, if Lordships required, then I read. That's I only mark paragraph number.
You are referring to Rahim Ali.
Yes, Rahim Ali.
Yes. We
Yes.
have that, you have marked about 15 paragraphs,
Lordships,
23, 24, 20, 23 to 27, 33 to
28 years,
46, and then 54.
Lordships. Very important in
Yes, yes.
this is Lordships. And also in regarding one family member, there my learned friend made submissions. My mother is alive, but she has not come before the tribunal to adduce evidence losses, but she admitted my mother is alive and mother is there. Mother not denied. And documents lordship, last occasion lordship I have annexed regarding NRC. One person cannot be picked up. Others are there stating they are Indian citizens. I also elaborately stating in my written statement, no dispute at all. One cannot be picked up, lordship. In the lordships, that documents lordships I have annexed in the writ petition lordships. Lordship will find page 74 of my writ petition. Last occasion, lordships, I have made submission in this regard, page 74. Results for all NRC applicants as per draft NRC and supplementary list of inclusion, exclusion, final NRC. Here, lordship will find my father's and mother's name. That was accepted. And page 76 losses, my name reflected, but rejected due to the piece. Serial number 3 lordship Rafika Bibi. My father's name Sofiar Ali, mother's name Jerina Bibi, husband's name Karim Box. Rejected DVD. Serial number 3 of page 76. Regarding non-considered oral evidence, your lordship passed the judgment lordships. WPC number 8243 of 2018. Non-consideration evidence, oral evidence and documental. WPC number 8243 of 2018.
Decided on,
Jamila Khatun versus Jamila
Decided
Khatun
on?
decided on lordships 11/11/2024.
name of the parties?
Name of the parties lordships Jamila Khatun, JMIL Jamila Khatun, alias Jumila, JIUMIL Jumila Khatun versus Union of India. And para 6 lordships
This is on what point?
regarding non-consideration oral evidence and documentary lordship. Lordship remanded the paragraph 6. May I read lordships?
Yes.
Thus the learned foreigners tribunal number 2 Nolbari has failed to discuss the evidence of DW1, DW2, DW5, DW6, and the said learned tribunal has also failed to discuss the exhibits number 2 to 6, 8 to 13. Under the circumstances, the court is of the unhesitated view that the learned tribunal has not properly appreciated the documents and evidences adduced by the petitioner, and as such, the opinion dated so and so is held to be not sustainable on facts and in law. Therefore, the said opinion dated so and so passed by learned tribunal number 2 Nolbari in application number so and so is hereby set aside and direct that the matter be remanded back to the said learned tribunal, which would be required to be appreciate the evidence and give a fresh opinion in accordance with law. In this regard, I have earlier produced two judgment also, lordships. Lordship has taken note in this one. And regarding name clarification, and Motiur Rahman Abdul Khalik also, and in respect of one singular note, my evidence and documents not challenged, not refuted. That is a foundational case also, lordship. They have to some rebuttal, nothing else, not challenged. Now they are taking a chance, lordship. That cannot be permissible. Lordship, all documented evidence here that shows the petitioner is the daughter so and so. It was not challenged, not any question, no, sir.
You were referring to this page 74 and 76. 74 you say is your projected parents.
Sophia Ali Sheikh.
Correct.
Lordship,
74 is your projected parents.
lordship,
And who is page 76? Who are they?
76. My name, serial number 3, lordship.
No, we understand, but who are the others?
Other family, my husband's family,
This is a husband's family.
husband's family.
Okay.
Number 2, Karim Sheikh, who is my husband, lordship. My husband's name also, right side, lordship, called Karim Sheikh.
Okay. Okay, we are reserving the judgment.
My lord, regarding rebuttal evidence, lordship, I am only citing one judgment of this honorable court. It is a reported case actually, lordship. 2018 4 GLT 360.
Just a moment.
Okay.
2018 4 GLT 360.
Just a moment. On rebuttal evidence, what is the case you are citing?
Lordship 2018 4 GLT 360.
2018 4
GLT 360.
name of the parties
State of Assam and another versus Ohab Ali.
versus
OHAB. Ohab Ali.
paragraph.
Paragraph 16, lordship. On the other hand, from the impugn order, we find that after narrating the case as projected by the respondent, tribunal observed that state did not examine any witness and failed to adduce rebuttal evidence. Therefore, tribunal.
We'll go through it.
Yes, lordship. And lordship, they are relying on oral evidence of one Mohiruddin Sheikh, lordship. And lordship, if we all these things has been considered, lordship, by the tribunal, lordship, and
We'll also consider it.
yes, lordship.
Land counsel for the petitioner, as well as Mr. G. Sharma, and it's standing counsel for the FT matters and NRC. Record the presence of others, Mr. Adi, Mr. Sharma. Arguments are concluded, judgment is reserved.
Obliged.
Hearing item 4 with item 5.
Met user losses. আমার এদিকে কিন্তু আমার কিন্তু কে নেব তাই নেব হলো I am appearing for the appellant. Item number 5.
Item 5, okay. Because
Item
Mr. Sutradhar says that he will depend on you.
Yes.
Yes.
The institute IIT is the appellant in 4. Item number 4. My employer.
So if you don't protect and insulate yourself, then he takes your advantage.
Here, question that would fall for your lordship decision. Is whether the appointment of the appellant in 5, item number 5, who was appointed as the assistant engineer. Post of assistant executive engineer. He was appointed to the post of assistant executive engineer after recruitment, after selection on the basis of the advertisement dated 25/11/2016. And that selection and appointment was challenged by the rate petitioner, the private respondent here, on the ground that I do not possess the qualification, and as such, I could not have at all been selected. It is simple. Now, therefore, question is, what is the requirement of qualification under the notification, recruitment notification? First, we have to see that. So, fact remains that I am a BSc in engineering. BS, Bachelor of Science in Engineering. That is the degree granted to me by BITS Pilani, an institute of eminence. and I got the degree in 2005. I started 2005, got the degree in 2009. Therefore, first Lordship will kindly come to page 47 of this volume. The recruitment notice, Indian Institute of Technology, Guwahati, has floated. 47, my lord, page. Last paragraph. Lordship will find Assistant Executive Engineer Civil 2 post. Minimum qualification. Kindly read this. Number 1, bachelor's or equivalent degree in engineering from a recognized university / institute. Page 47.
Here we are there.
So, then 2 requires minimum 6 years of working experience. To have experience in estimating this and that. This is the experience part. The first thing, I will pause for a moment here and press this. It says bachelor's or equivalent degree in engineering from a recognized university / institute. It says that a degree from a recognized university. It doesn't say that a recognized degree of this kind by any university or any institute. Construing this particular clause in my respectful submission, to my understanding, humble understanding, it requires only that the degree must be obtained from a recognized institute or university. And I fulfill that. BITS Pilani is not only a recognized university or institute, it is an institute of eminence. And I find in the list it ranks 1 in the country. And it has its eminence all throughout the world. It is a deemed university. The law is subtle. In all such recruitment notices, the qualification clause, as it is mentioned in the recruitment notice, should be adhered to. There being no question raised so far the recognition of BITS Pilani, there was no occasion in my respectful submission for the learned single judge to hold about the legality of my degree. Learned single judges say that this degree is not a recognized degree. In my respectful submission, this was totally not required. It was not at all required to come to that aspect. Because the degrees, presumption is that the degree is granted by the institutes which were already recognized and deemed to be universities, and the institute of eminence are automatically recognized. Are automatically recognized by notification of the government. as well as under the University Grants Commission has also subsequently clarified it. That there is no question. They can themselves do it. It is a deemed university. University is competent enough to do it. Therefore, a finding which was recorded by the learned single judge was going astray from the main question. P44. Kindly come to the learned single judge's judgment at page 344. P44 and except 30.
Just before that,
Yes.
page 64.
Page 64, my lord, this is
Yes, last serial number 3.
Yes.
Yes, engineering technology.
engineering
Therefore,
technology.
you are a bachelor of engineering technology.
Yes.
Is engineering technology and
Yes.
engineering same?
Yes, well, they have said this is equivalent to this BE, equivalent to Bachelor of Engineering. A Bachelor of Science in Engineering, they call it. BS Engineering Technology.
No. The question is whether engineering technology
Yes.
is same as engineering.
Yes. The course so devised by them and imparted, they say that it is equivalent to BE. I will come to it. I'll show it. But question is, my lord, question is per se, going by the advertisement, recruitment notice, this question could not have at all been raised. Even if raised, it would have not carried any water. Because the requirement is that it should be from a recognized institute or university. That being the position, only to that extent it is to be seen which is the institute or the university from where I have obtained the degree has the recognition or not. And more particularly, Lordship will also kindly note my lord, another important aspect I want to point out. I was employed by the IIT Guwahati. it is the employer who is to decide about my qualification, whether I am qualified or not, whether my degree, I mean, the degree could have at all been acted upon. It is for the employer, primarily for the employer. And here none other than an institute of IIT Guwahati. It's a technical institution. It is not like any other university, conventional university imparting humanities degrees in sciences or humanities getting expertise in other subjects than the engineering. It is not that. It deals with engineering and technology. Therefore, this is another vital aspect to be kept in mind, that the authority acting upon this selected me and appointed me.
Mr. Mahanta, I don't have a, Mr. Mahanta,
Well,
you see, I'm looking, looking in introspection of my own educational qualification. I did not join science because I was a bit weak in maths, arithmetic, in fact. I was a bit weak, and therefore, instead of this, I went to commerce. But when we speak of an engineering degree, engineering is basically arithmetic and maths. For everything, they would need some calculation to arrive at a functionary application of that degree.
maths is a
But-
compulsory.
But once it comes to engineering technology, then when I looked in this, look to the present scenario of computer engineering and engineering technology in computers, then there's a remarkable difference in it too. Because engineering in a computer and what you call technical engineering in the computer are two different scopes.
Yeah.
Because one goes to computer architecture, one goes to computer applications. And there's a vast difference between the two. One is basically dependent on the basically in what you call the hardware and the
Yeah.
application and there, and one is and when it comes to technology, then they give you real-time solution. For example, you need in your chamber that there should be a computer which can some data can be put in, and they will generate the AI presumptives of
Yes.
what would be the solution, what would be the what you
The
how do you
functioning, the
how do you-
internal functioning of hard rock. I mean the hardware.
no, there's something more. Now what they are doing is they also profile the judges who are taking up the matter, that
Yes.
these benches of these judges and they have their past
Yes.
judgments are
can-
this way, so therefore there will be a presumptive assessment of what the outcome would be. So there is two different scopes altogether. So I have some reservation to accept that engineering degree and an engineering technology degree would be same.
Same. For that, Lordship will have to see what is the course content. Because fact remains that I come from the engineering background. I was,
Your course is here, page 64, engineering
Bachelor of Science and
No,
Engineering Technology.
in the fifth column, engineering,
BS
BS,
Engineering.
MEAS, we don't know this full form. Then program planning and
Engineering, match,
I don't know, MEAS. I
engineering,
don't know the real form.
CAS.
MEAS, I don't know the full form. Then there is pro plan, I think program planning and
Yes.
con assurance. That's quality control assurance.
Quality control assurance
And RELA, I don't know the meaning, engineering matter, engineering maths, etc.
Engineering, maths, etc.
So it's more into technology
Yes.
than pure engineering. But I have my limitations. I am a commerce graduate.
Malad, for that, for time being, Lordship will see how this program which I have completed, they innovated a course, the institute. It is called WILP, Work Integrated Learning Program, under the guidance of an adjunct faculty in the institute, and had to undergo all courses under his guidance and submit it to the authorities and then write the exam. Though online, but it is not exactly online or not
No, for
exactly,
this,
I mean,
for this,
encompassed.
for this, there will be an academic, will foray into an academic issues, because you see what happens now. In some universities in the country, when you take LLB examinations, LLM examinations, then you are given a question paper to take home and then write. You get 42 hours. Some papers are 72 hours. You get time and you compile the answers
Yes.
and give it.
Right.
But the one or two queries which I had an occasion to go through, I find that even I was not equipped to give that answer. So it's although they give the question papers to take home, I was under the impression if I take the question paper home, maybe out of 100 I'll get 101. But I was wrong. It was a very difficult task. So therefore, you see, what is the course is not the criteria. Whether this degree of engineering and the engineering technology, they can be considered, because the learned single judge came to a finding that it is not.
It is not.
Because-
It is not. But there my point is, my lord. Now, who is to decide this question? This decision is to be taken by an expert body. The expert body declares that this is equivalent to, and it is acceptable to, and government has also issued notification, central government, that this is, so far the employment in the government, under the government is concerned, it should be recognized.
See page 351, very specific finding.
(351).
351.
Yes,
That WILP and all those are taken care of.
yes.
And then last paragraph, paragraph 13 of the affidavit is quoted.
Yes,
Answering respondent so-and-so submits that has never been a specified degree of so-and-so.
yes.
And that is why this
22.
Now we.
page 351, paragraph 14,
Yes.
paragraph 13, in paragraph 13, para 13 is quoted. Para 14,
Milad,
referring to the stand, it says that it's not a recognized degree by the UGC.
Milad, at that time, UGC had no role to play. That part, my lordship will read it along with their affidavit at page 244, that paragraph. UGC's affidavit. UGC has created this confusion by the statement in paragraph 13. They ought to have made it clear. Paragraph 12, probably lost sight of by the learned single judge. At page 244. At the relevant time, it is the authority called Distance Education Council under the IGNOU Act. Lordship got it, my lord, page 244,
Yes.
paragraph 12. The previous regulator of distance education, namely the Distance Education Council under IGNOU, had accorded as ex post facto program-wise approval to work integrated learning program with effect from 1995 to academic year 2007 and 9. Vire number so and so, dated 24/11/2009, only to BITS Pilani, Rajasthan. This is their statement. Therefore, at the relevant time, it is the authority which was the appropriate authority. They have recognized it. Recognition
No,
was there.
recognition is one part, but para 13 says it never been a specified degree. It never means past and present.
Well, a specified degree under section 22 of the UGC Act, they say. But I'll place that notification of the UGC itself, 2017. They have made it clear because why these degrees were granted or how these courses were innovated. What is the purpose behind? One thing Lordship will kindly remember. I am not from, Lordship is right in referring to computer science and operation and computer engineering. Because there, for one branch, science background is not required. In other branch, yes. Here, I am from the science background. I am having a diploma in engineering. And I got the opportunity to pursue the higher degree course under WIL, launched by BITS Pilani. And that was an approved course. That was an approved course recognized by then regulator was DSC. So UGC has nothing to do. Up to 2005-8, they say they up to 2007 and 8. That was those who have entered during that period, that was regulated by DSC, that was already recognized. University Grants Commission has no role to play at that time. And under the DSC, under the IGNOU Act and the subsequent notification of the UGC, such courses, such degrees are not only recognized, it specifies that the institute can itself recognize the degree. New courses are coming up, my lord, new thinkings, innovations are being there. That is how they have done it. WLP, it was in here. To know how and what is the purpose and how the course has been designed, whether it is an engineering course or how it has the carry any relationship with the engineering and all. For that, Lordship may kindly look into page 162. It is the notification issued by BITS Pilani, so far WILP is concerned. Let us have that for the time being to clear our doubts.
Page number
162. This was notification issued to clarify the ground after the decision of the apex court in Odisha lift irrigation case, where the Supreme Court said that this engineering degrees or diplomas granted by the institutes, which even do not run any engineering courses within their campus, those cannot be recognized, which were ultimately granted online there. In that context, Supreme Court classified that technical educations imparting distance education is one thing, and the non-technical institutions imparting online course or distance education in engineering is completely different.
yes.
My lord. Kindly come to 162 for the timing.
Yes, I'm there.
All right. I'm reading it, my lord. It was addressed to all stakeholders. We are aware of the Supreme Court in its recent judgment of November 3, 2017, in the matter of Odisha Lift Irrigation Corporation Limited versus Robi Shankar Patro and others, has suspended the engineering degrees awarded by certain deemed to be universities and also restrained all deemed to be universities to carry on any course in distance education mode from academic session 2018-19 onwards, until it is permissible to conduct such courses in distance education mode and specific permissions are granted by concerned regulatory authorities. The judgment, though, was delivered on the facts of the case before the Supreme Court, but we are mindful of the apprehensions it may cause amongst our students with respect to the validity of the degrees awarded by Birla Institute of Technology and Science, Pilani, BITS Pilani, under its Work Integrated Learning Program, WILP. It is important to share again with you background and the genesis of the WILP for better understanding of the judgment and its implications to WILP. About WILP. WILP are specifically focused on the higher education and upskilling needs of industry professionals integrated with the work environment and are conducted with the same rigor as campus-based programs with a very high component of synchronous instructions and the use of the latest educational technologies. BITS is the pioneer of WILP, and till date the model of WILP is one of its kind in India. BITS Pilani started its WILP in the year 1979 and evolved it in accordance with the objectives of the National Policy of Education 1986 amended in 1992. That is to increase width of higher education in India.
But this is just a sort of pamphlet,
Well,
an explanatory note,
explanatory note to clarify their position.
but that's okay.
Yes.
You see, they are just, I have cursorily read it. At page 163, they say that we like to reassure the students.
Yes.
So it's a letter of assurance.
Well,
This is what it is there and it has credibility, and they say that.
they have themselves said it. They have themselves explained it, clarified it, how it was designed, how it was done. Because the fact remains
A
that
few days back, I also gave a speech where I said, I did this, I did this, I did this, I passed this judgment, I passed that order. And then I was booed and I was thrown away. Yeah, I was.
well, Lordship will excuse me, because things, certain expertise is possessed by certain persons, certain executives, certain institutions. It is for them to explain. I cannot explain it. Therefore, it is for them. They will have to explain it. Otherwise, how can one believe it? If someone can challenge it, yes, okay. But that has not been done. Rather, the government has already recognized it as the Institute of Eminence. As the Institute of Eminence. Therefore, my respectful submission, what they have said, they will not say for publicity alone. They have the responsibility to explain the truth to the people. From that point of view, it carries weightage. My respectful submission. They cannot just only for the sake of publicity say something. Such an institution which has the eminence all over the world.
We take note of your submission.
Yes, my lord. They have clarified that the wheel in beach Pilani is therefore different from the traditional open-end distance or correspondence learning program due to the reasons stated hereunder. Enrollment is permitted only to suitably qualified employed professionals. These are for employed persons, not otherwise. Employed professionals having specified educational qualifications with adequate and relevant work experience to programs that are closely aligned with their work profiles. I'm a diploma engineer. I was working in that field only. Enrollment is permitted only to suitably qualified employees, professionals having specified educational qualifications with adequate and relevant work experience to programs that are clearly aligned with, yes, their work profiles. Enrollment also requires endorsement of the employer and a commitment from the employer to provide necessary support, including that of a qualified mentor and facilities to enable effective work integrated learning. The rationale is on the one hand to achieve more effective integration between the academic content and the activity at work, and on the other that the skill and knowledge enhancement attained by the employee through these programs would ultimately benefit the organization by increasing productivity. So,
No, Mr. Mathur, we are not disputing what you are saying, but the moot question is whether it is an equivalent degree.
yes, whether it is a recognized equivalent degree. Now, for that, Lordship will see.
You are saying that the UGC affidavit is misleading. And
197, kindly look into, madam, please. One 197, madam.
yes,
This was by the Ministry of Education and Culture, Department of Education, 7 June 1982, addressed to the Vice Chancellors of all the universities. During the recent discussions in the Parliament, when the Union Education Minister was answering a specific question about recognition of the university awards for purpose of employment under the central government, it was mentioned that the degrees, diplomas awarded by the various universities are not given the same recognition by various agencies throughout the country. In this connection, it may be mentioned that as per the Ministry of Home Affairs, OM number so-and-so dated 19th April 64, in the cases of degrees, diplomas awarded by universities in India, which are incorporated by an act of the central or state legislature in India and other educational institutes specified, established by an act of parliament or declared to be deemed as universities under Section 3 of the University Grants Commission Act 1956. No formal orders recognizing such degrees, diplomas need be issued by government. Such degrees, diplomas should be recognized automatically for the purpose of employment under the central government. It says, central government notification. Further, reading 3, my lord. While this act of the central government recognition may be known to various recruitment agencies, including state government and other authorities concerned, the fact that a particular degree, diploma, etc. is being awarded by a particular university might not often have been brought to the notice of the authorities. It might facilitate to a very great extent the matter of according appropriate recognition by recruitment agencies. If the various universities mentioned in paragraph 2 above periodically bring to the notice of the recruiting authorities the details of their degrees, diplomas, and other awards. This is particularly so when the universities start new courses of studies. The same procedure might be followed for the purpose of mutual recognition of the degrees, diplomas, etc. awarded by the various universities among them. This was from the Education Department. Then 250 kindly come.
Just a moment.
Well,
This is going to go to slide. Grants Commission. And that's assembly. Mr. Mahanto,
My lord.
normally an engineering degree would take how many years to have a degree?
4 years.
4 year degree. Please come to this page. Uh, 275.
Yes.
275 says,
Mm,
address to you,
Yes.
admitted in first semester
Yes.
in 2005, 2006. Last rated second semester is 2008, 2009. So therefore, degree is awarded
In 2009.
in 2009. So 5 and 4, for these 4 years. Okay. Just a moment. Please proceed.
So at the entire period, I had to undergo the instructions and I had to pursue the course.
It's okay. We did not understand that document. That's why we asked you.
Yes, I'm grateful. And then
Because they write second semester. So knowing LLB, first semester, sixth semester, 6 months, 6 months.
yes,
How is the degree being granted? That's why
Yeah.
that question.
but they have devised it in 2 semesters. 2
No,
years.
it's okay. I have no idea. So there was a query. And with that query, if I keep on hearing you, it will be half-hearted hearing.
I think, my lord, it will be a different field altogether.
Pardon me?
That will be a different issue altogether. So therefore, Lordship is right in pointing out as to how this was done. We have said that in 2004, 5 or 5, 6, I entered first semester, then second semester, 2008, 9, I had to complete. And thereafter only the degree was there.
It's okay. There was a.
Yeah.
We'll continue after lunch.
Yes. Sorry.
Mr. Mahanto, you can urge on the bullet points and then elaborate because we have very limited time. And we don't want to spill over to another day.
No, not necessary. Because my campus is very narrow. But then, since these questions are coming, I am placing that those documents which will lead to show that yes, this is a recognized degree also. There is no doubt on that. Automatically recognize that I have already placed that notification of the central government and addressed to the university authority. And then kindly look into page 250. Is a gazette notification of the Ministry of Human Resource Central Government dated 10th June 2015. This has some bearing, Lordship will kindly see. It says, whereas by the notification of the Government of India, Ministry of Human Resource Development, so and so, number 44, 1st March 1995, published in the Gazette of India, Part 1, section so and so, it had been decided that all the qualifications awarded through distance education by the universities established by an act of parliament or state legislature, institutes deemed to be universities under section 3 of the University Grants Commission Act 1956 and institutions of national importance declared under an act of parliament stand automatically recognized for the purpose of employment to post and services under the central government, provided they have been approved by Distance Education Council, Indira Gandhi National Open University, New Delhi, and wherever necessary, by All India Council of Technical Education, New Delhi. And whereas the Ministry of Human Resource Development, Department of Higher Education, with its order dated 29th December 2012 and 25th January 2014, has entrusted the regulatory work of open and distance learning mode as a education in the higher education system to the University Grants Commission. That has come from 14 only. And whereas Indira Gandhi National Open University, with its notification dated 1st May 2013, has dissolved the Distance Education Council of the university. Now, therefore, the central government hereby notifies that all the degrees, diplomas, certificates, including technical education degrees, diplomas awarded through open and distance learning mode of education by the universities established by an act of the parliament and state legislature, institutes deemed to be universities under section 3 of the University Grants Commission Act 1956 and institutions of national importance declared under an act of the parliament and stand automatically recognized for the purpose of employment to post and services under the central government, provided they have been approved by the University Grants Commission. Now, University Grants Commission has said that at that time it was the regulatory authority was the DSC, Distance Education Council. That Distance Education Council, what is it? Lordship will find here this one document. No. Here the documentation is here. DSC. Willard, kindly look into at page 308.
Samantha, is your degree a open university degree or it's a regular classes?
No, this is
Distance mode.
distance mode, but not, it is exactly not a, hmm? not a distance course, but also not an in-campus course. It's an off-campus under the guidance of a mentor. By the university, this is the same. Why the chemical? What is that? Hmm? This is, well, at the Annexa P, 308 page. It is a recognition accorded to universities, institutions for offering programs through distance mode. After all, this is a distance mode, but kind of unique course with a mentor. The erstwhile DSC has not accorded approval to any specific program offered by the university institutions, and it is the university institutions to decide the program to be offered through distance mode and seek approval of the statutory bodies of the university and other apex bodies wherever required. It is the body of the university itself. Now, territorial jurisdiction, Lordship can skip over. Study centers, this is there. And technical professional programs, Lordship will find in the fourth column. In case of technical professional programs offered by the university is concerned, wherever required, approval from the concerned apex bodies in the country, such as AICTE, NGTE, etc., is required to be obtained, for which the responsibility vests with the university concerned. Now, then states, name of the states, name of the university, all that is there. Lordship will kindly skip over. Next page, 309. 142 serial number is a big list. We have just taken out from there. Rajasthan, state is Rajasthan Birla Institute of Technology, deemed to be university. Duration of the program, academic year 1995-96, 2007-2008. Post facto program wise recognition. It is by the university, UGC. ME, then all these degrees are there. MBS, BS, Lordship will find BS there. This is in pharmacy operations. Then kindly go little down. Collaborations. BS in pharmacy operations, technological operations, industrial management, engineering technology. Yeah. What you've got in my lot, 309, last column.
But this document itself appears to be incomplete.
It is in it's big list, my lot. It is of all the states is there. It was issued by the UGC. My instruction is this. It's a big list. And serial number 142 states the name of Rajasthan. Page 309. They have given the list of all the institutes of the states of the country, and then they said their requirements and what degrees they can. Their Lordship will find Birla Institute of Technology, they have shown ME, MBS, then BS in pharmacy operations, BS in technological operations, industrial management, engineering technology, information system, process engineering, engineering and industrial technology. So all this is there. So I come in power engineering, nautical science, industrial engineering, technology, manufacturing, all this is there. It was taken from the website, UGC website, man. This was post facto program-wise recognition was granted for that period 1995 to 1996, then 2007 to 2008. BS Engineering.
Because you see, why we are asking this question is,
Yeah.
you please come to page 302.
Malo.
Last 4 lines, the BS Engineering Technology program and the duration of the recognition between so and so to 2007-8. Your degree is 2008-2009. Now, for this, says that respondent number 5 on the recommendation of the Empowered Committee on 548 meeting held on 9/9/2020 has continued the BITS Pilani to impart different programs. Now, so you see, the decision is taken in 2020.
Yes.
They give you recognition till 2008.
Mm.
What happens to 2009? How is that saved?
No, 2009, I got the degree. I completed the course, 2005, 6, 7, 8.
We don't know. That's why we asked you that earlier also, the same thing.
Yeah.
Your
Well, here, even thereafter also, this is being continued. That is what
no,
this
continuing
contention here
something
is.
else, but once you are showing empowerment,
Yes,
that empowerment is for a period, the decision taken in 2020
yes.
till 2008. Now, let us come again to your degree. That document we were asking questions.
That page Lordship pointed out to me, 62. না এটা তো ইয়াতে দেখাছিলে 62 তো কোথাও নাই আমি এটা এই হেৰি
That is page 275. Second semester registered second semester is 2008-2009.
Yes.
End of the second semester 2008-2009. 275 last paragraph, third last line.
Academic requirements of graduates and
What are the degree at the end of second semester 2008-2009?
date of approval by the second division, second date of approval by the examination committee, 16/6/2010, 6/2009. Date of issue 7/7/2009.
So you see, we are only on that 2009,
Yes,
and the degree which you have received is at page 277.
yes.
It was issued on 20th day of August 2009. So that the study period up to 2009 must be approved. 2008 is approved, 2009 is not approved.
No, the course content therein was approved. Certificate when was granted is not material.
No.
Course
The
content.
document which you are now reading
Yes. This
was this lecture P.
hmm,
Was 308 you were referring to.
309, yes. Yes.
308, the approval,
Yes.
duration of recognition for academic year,
Yes.
that is the column.
Yes.
Academic year is 2008. 8 and 9 is not covered.
Yes. 95, 96, 2007, 2008. Up to 2008 academic year.
And that is your statement in your affidavit also. That's why we are referring to that. That statement is,
Duration of recognition academic year, yes, 2008. Now let us see, thereafter, post facto approval was granted.
up to 2008.
No, thereafter also,
Okay.
thereafter also. I'm sorry, I could have read this, the third column, that.
You wanted to say something?
Yes, yes, all these situations is being taken care of by the Honorable Supreme Court in 2018, 1 SCC 468, Orissa Leaf Corporation.
No, we'll come to it. We'll come to it, my lord.
This is covered by that judgment
That's
and
okay.
all.
Let Mr. Mahanto
Yes, yes,
make his
Come
submissions
to it
because
later on, ultimately, because complications has been created by them only.
Degree of those periods granted by the deemed to be universities through distance mode, all technical degrees were set aside. And they were
No,
given
not
a.
all.
Just wanted to-
No,
I'm
it's
just-
okay.
I'm aware of it, not all. Had it been so, I would have said I have
Because you see,
no
when Mr. Mahanto is making a submission, we can't hear you. That's very
Yes, of course.
and that will be a disrespect to Mr. Mahanto.
I
He's
am
a
not-
senior counsel and then you disturb him.
Had it been the case that High Court, Supreme Court has already said something against me, there is no point on my part to keep on arguing on a
No,
non-existent.
it's okay,
Why should I?
but still,
I may try to distinguish it, only thing is this. But as I say, my lord, here, at the beginning I said, the Honorable Supreme Court has found two group of institutions. One is with technical background, the other is without technical background. They have said regarding without technical background. Even Lordship may kindly turn to at this stage to this, I'll just, Lordship asked me that question. UGC's, what is the latest position of the UGC approval? 312 means. No. Is there post facto approval? 284.
no, because you see, Mr. Mahanto,
My lord.
let me clarify on the legal position.
Yes.
Mr. Mahanto, in this page 302, you and the earlier document you read, you said that the Distance Education Council was discontinued.
Hmm.
Correct.
Yes,
And that you will find is your pleading in 302.
yes,
You say the Distance Education Council was discontinued.
Yes.
And thereafter, the empowered committee if this 2007, 2008, this empowered committee must be some organization which is outside DEC because DEC is discontinued.
yes,
Somebody must have taken that decision
yes,
and they take a decision up to 2007 and 8.
yes.
Either
That is by
there
UGC.
will be two options. Number one, after 2007, 8, in the absence of DEC, somebody else is taking a decision. So therefore, 2007, 8 is validated. 2008, 9 remains. We don't know about that. So, and the date of discontinuation of DEC, that is also not known.
That mentioned there, my lord.
No, we understand, but
Yes.
since we did not think it relevant, we did not
Yes.
record the date of dissolution of
Yes.
DEC.
This is correct, that DC was not there.
DEC was not there. So therefore, 2008, 2009, somebody must have approved it. Or it can be also your case that in view of the provisions of section 22 and the notifications issued by the Ministry of Education, what happens is that these are automatically recognized. So there we have some doubt. You will have to bring clarity to that.
Yes,
aspect.
I will come to it. Because question is, that one thing has been said by the apex court, that when there is a statutory provision, probably the central government by notification cannot do something. But if this is provided within by the law under which the institution was created, founded, then of course.
Because that lift irrigation had a very cascading effect on all this.
Yes,
This what you call in Meghalaya also that university went.
yes,
There are until numbers of universities degrees which have been invalidated because of that judgment. Because then comes a second round
yes,
where the law laid down was that they cannot be outside state campus.
Yes, yes.
It can only operate within the territorial
what is
jurisdiction
it?
of the university.
Yes, exactly. That was there. But here it was an exception. This, they have taken it as an exception, this particular course. So therefore, it is being continued even now and it has been approved by the UGC now. UGC took over.
In fact, to cut short these things, I asked you the only question,
Yes.
whether this is an incomplete document or complete document. But then would have understood who took the decision. This circular is what do you call this, recognition is by which authority?
Well, I'm told that this was taken from the website of the UGC website. This is how NXP we have shown there in the affidavit. So when it is from into haters all component, upload kolu kihat. Definitely, I presume that this was by the UGC itself,
Maybe,
or may not be.
no,
but-
maybe we are not questioning you right now on that.
Yes, yes. What is it?
No, it's okay, you can proceed further. This
Yes.
will be something which will, that's what Mr. Samoa will be able to tell us.
What is it?
You can continue with your submissions.
Mr. D2A2. Nineteen 95. Oh, yeah. 2008, 2007, 8, you look at the huh?
So Mamta, you can leave this point in your argument, reply argument, you can address that.
No,
You get sufficient time to.
Just place those documents which may throw some light on your lordship's query. A notification was issued by All India Council of Technical Education. Lordship may kindly turn to 297.
We, you see, we are still giving you time. There's a reason for that. That's why we omitted that and went and wanted to proceed further. Come to page 303. In 303, first subpara you say, copy of the relevant portion taken from the website of respondent by UGC. Therefore, once you plead UGC, you can't go back to AICTE.
No, my lord, what happened?
No, we don't know. That's why we are giving an opportunity, and the reply time you can
No, no.
satisfy us. We are omitting this for the time being.
Okay.
We just put you the query and the reply argument you can give it.
Yes, yes. So, 297, huh? Yes. I was referring to 297.
Yes, we have seen that.
Yes.
But that is AICTE. That will be.
AICT. AICT has said, accordingly, council, the second para,
Yes.
accordingly, council in the 52nd emergent,
No, but that is 548th meeting. That is 548 meeting. That's why, Mr. Mahanta, we stopped you there.
Yes. No, this is by AICT.
This is by AICT and 58th. In your pleadings, you say 548. So that's why.
548 is, there is one more.
No, that's why we are not asking you an answer right now. You can give it later.
284. Just a minute. 82. At 548, Lordship will find it 280.
We understand. But this is not 548. Therefore, there must be something more. Next time when you give a reply, you can add, oh, yes, we'll take it.
Right. Right. So, I just wanted to show that even AICT also approved it and the University Grants Commission also taken it. Academic to Coastal University Grants Commissioner. 240. What you will see in their academic, they have said. They have said.
No, but Mr. Mahanta, when you are showing us AICT, I have a different set of questions for you.
Yes. Whether AICT ever took over.
No. The question to you is
Yes.
that this is an equivalence to the diplomas are equivalent to our degree.
Yes.
That's what he said. But your case is that you have a degree,
Yes.
which is not a diploma.
Is it true? Let me just read it because here.
No, we told you the pleadings we are
No.
we have seen that. Therefore, once you refer to this,
Notification. Lordship has said that only it speaks of diploma. In
because you
that-
see, come to paragraph, second paragraph. Accordingly, the council in its so-and-so meeting held on so-and-so decided to recognize equivalence of all purposes, including higher education, technical courses conducted by various so-and-so, which were duly recognized by MHRD with permanent recognition of so-and-so.
Yeah.
Therefore, it is only with regard to a equivalence for the degree. There can be an equivalent to a degree. There cannot be an equivalent to a diploma.
Equivalent to a degree.
That's why once you say that you have a degree in bachelor in engineering, we are not going back to a diploma. Diploma is in 84. Your diploma is in 84.
Well, equivalence. Let's see. Let
No,
us,
leave this for the reply.
okay.
Leave this for
Let them
reply
know.
because we understand. You see, this is a question we are asking because I have a bad habit of correlating documents with a pleading.
No.
That's why
This
it's a bad habit developed.
This, in fact, this is the habit. Well, I cannot bring in something without a pleading.
It's a bad habit developed there when I was there earlier.
Without a pleading, how can I bring in some? Without permission of.
That's
the-
fine. We just,
Yeah. I have to take
Mr. Mahanta,
some.
please take it. We are not doubting your statement.
No.
But since we want a better answer, we're just leaving it this point so that you can add it in the reply. We'll take it from you.
So Lordship now want to hear him.
No, because you see, so far as I have understood, just let us recapitulate.
Yes.
You want to say that number one, that the degree you have
Yes.
is an equivalent to degree of science.
Science. With a B.
Yes, engineering. And then you are trying to say that whatever degree is being granted is approved by the competent authorities.
Yes.
And they are accepting those degrees by dint of section 22 of the UGC Act. And therefore you are saying that these are valid degrees.
Yes.
And you are also saying that by referring to section 22 of the UGC Act, the learned single judge has misapplied that that provision in the negative against you.
Exactly.
And then you say, to your point number one, that this question could not have been issue for determination, degree being otherwise valid. And so therefore, whether the degree in degree of bachelor in science, engineering, BSc in engineering technology is equivalent to that of an engineer, degree of engineering. And once that is recognized by the employer, you say that this,
Yes.
it could not have been interfered
Could not
with.
have been interfered.
You
that
are
could
relying
not-
on any case laws on the point?
Well, here the.
Mr. Mahanta, I'm not stopping you from your submissions. Mr. Mohanto,
My lord.
I'm not stopping you from making submissions, but I'm trying to just, since we have certain, what you call, issues with time.
Yes. My lord, I know questions are hitting your lordship's mind. Lordship will put it to. And I will have to take note of and reply to it. Because any doubt which may come
No,
to
the
your
reason
lordship-
is not that. The reason is that you see, we are hearing a few matters which are parted.
Yes.
So we don't want to make it a parted matter.
No.
Except for your reply, we don't want to make it a parted because we have now started the APSC matters. There are two different benches we are hearing.
Yes, I'm
Therefore,
told there is another bench also.
So.
This is there, my lord, but at the same time, my lord, unless the facts and law is thrust out, probably.
No, it's okay. That's why we are recapitulating what you are trying to say.
And for that, a little more time may be given, if not today itself, tomorrow day after.
Reply when
Yeah.
at these things.
Yes, yes. Let me place, I will place the decision, put it now for you,
Yes.
right? My lord, regarding equivalence of degrees, my lord, put to decision, it is a quote of the decision. No, no, I would say it is quote of the quote of the. It is so haphazardly placed, my lord. Difficult to remember all these things now. It is a more-
Mr. Mahanta, we'll also request you,
Yes.
when you, we'll take the citations, no problem with that. But at the end of the day or tomorrow morning, just give it to the court master, the case numbers, the paragraphs, and on the point which you are relying on.
Yes. Not quite serious. Not quite awesome.
Ms. Begum, you can give it tomorrow. It's not necessary right now.
My lord, page 289.
Yes.
This was by the University Grants Commission, dated 14/10/2013. Addressed to the Registrar Director of all Indian universities, deemed it to be universities and all, institutes. Subject, equivalence of degrees awarded by Open and Distance Learning, ODL, Institute at par with conventional universities institutions. Second paragraph, then third paragraph. Here we find, my lord, the University Grants Commission took over on by notification 29 December 2012. This is fifth paragraph, my lord, says, as you are aware, the government of India has envisaged a greater role for the open and distance learning education system. The envisioned role may be fulfilled by recognizing and treating the degrees, diplomas, certificates awarded through distance mode at par with the degrees obtained through the formal system of education. Open and distance education system in the country is contributing a lot in expansion of higher education and for achieving target of GCGR without compromising on quality. Non-recognition, non-equivalence of degrees of ODL institutions for the purpose of promotion, employment, and pursuing higher education may prove a deterrent to many learners and will ultimately defeat the purpose of open and distance education. Accordingly, the degrees, diplomas, certificates awarded for programs conducted by the ODL institutions recognized by DEC erstwhile and UGC in conformity with the UGC notification on the specification of degrees should be treated as equivalent to the corresponding award of the degree, diploma, certificates of the traditional university. Last paragraph. It says to be treated as equivalent. Traditional degrees granted and degrees granted by the institutions or universities through distance education system. This was in 13. Okay. কি আছিলে? 2010 না? Next page, Lordship may see the page 291. It is by the Birla Institute of Technology itself. Office memorandum they have issued. Subject equivalence of BS degrees. BS equivalence, BS is for slightly marked.
Integrated.
The Bachelor of Science, BS degree, which are
The Bachelor of Science degrees which are integrated.
person. My friend will read out that particular portion.
The Bachelor of Science degrees
Look up,
which are integrated final degrees.
page
Page 291.
291.
291.
Integrated final degrees, na?
Integrated final.
Written are written here.
Offered free.
No degree to kitab
Which are integrated.
which are
Integrated final degrees awarded by this institute offered through our campus. They come back about.
Should I read out, my lord? I have a better copy. The Bachelor of Science BS degrees, which are integrated first degrees awarded by this institute, offered through off-campus distance learning and collaborative programs, are equivalent to the on-campus integrated first degrees of the institute as a BE honors, MSc technical, B Farm honors, MMS and MSc honors. The holders of BS degrees are eligible to seek admission to higher degrees program of the institute such as ME, Master of Engineering, M.Pharm, MS and PMPhil. This was the notification issued by the institute itself that these are equivalent. They also declared it as equivalent. It is more common advertisement to the port of Puhita Kashi, so it is put aside. Advertisement, huh? Wait. এই কোর্টে করেছিল না? And University Grants Commission. And then Lordship, that 548 meeting of the UGC on 9th September 2020. At page 281. It starts annexed D. Here at page 284. This is the minutes of the 548th meeting of the University Grants Commission held on 9th September 2020. The following officers of the UGC attended the meeting. Then section 1, this section 2, 4, at page 4, well, at the internal page 4, 284, running page. 2.02, that is, to consider the recommendations of the Empowerment Expert Committee on establishment of new off-campus by institutions of eminence and continuation of work integrated learning program by BITS Pilani. Considered and approved. Further, the Commission approved the recommendation of the Empowered Expert Committee to allow BITS Pilani to continue with its WILP program. However, BITS Pilani will have to strictly comply with the UGC guidelines in this regard as and when issued. So this scheme is still prevailing, this degree is still being granted, this course is still being continued and approved by the UGC. And UGC has already declared the equivalence, as I have already placed this. Oh, you have to go back on this again, no? Yeah. At page 289, it was selected. Hmm? Hmm. Therefore, notification to go down the procedure, yeah. Photo design. In my full submission, it leaves no doubt that this degree was recognized, its equivalence was recognized, and the course is still being continued.
But then, Mr. Mohanto,
Well,
when you are referring to these documents, it gives an impression that all these approvals are post facto. And post facto admission is something which in the Odisha lift irrigation, Ravi Patra or something.
by the non-technical institutions,
Okay,
there Supreme Court said. That
okay.
even that is not, because they
It's
do
not
not,
applicable on you.
sorry,
It will not be applicable on you.
yes. Supreme Court says that these institutes who even do not run any course, technical course in their own campus, how can they impart such courses through distance mode?
Okay.
So post facto approval has nothing to do with it. That is what the Supreme Court said. They do not have any expertise, not to speak of expertise, no course is there within their campus. That is what Supreme Court said. That's how it distinguishes the two groups. And regarding my lord, these such institutions which are deemed to be universities or institutes of eminence, University Authority Grants Commission, University Grants Commission had issued a regulation in 2017. If your lordship kindly look into it, it will throw some light. What is the purpose? Why? Whether they can.
Is it
It is, my lord, I have downloaded it, printed out, taken from. Internal page 14, lordship will go, that notification English version. This is called to create a distinct category of deemed to be universities, called institutions of eminence, deemed to be universities, which would be regulated differently from other deemed to be universities, so as to evolve into institutions of world class in a reasonable time period. The University Grants Commission, in exercise of powers conferred under clause F and G of subsection 1 of section 26 of the University Grants Commission Act, hereby makes the following regulations, namely, this is UGC Institutions of Eminence deemed to be universities regulation 2017. It shall apply existing proposed institution not owned or controlled by government seeking declaration or having been declared as an institute of eminence deemed to be university under this regulation. Regulation shall also apply to government owned and controlled deemed to be universities which have been declared institutions of eminence under UGC Declaration of Government Education Institutions and Institutions of Eminence Guidelines 2017 to the extent mentioned in the regulation. To deem to be universities declared an institutes of eminence, all these are applicable. Then campus definition goes, constitute institutions empowered expert committee is there. Off-campus, lordship will kindly see 2.12. Off-campus center means a center of institutions of eminence deemed to be university beyond its campus and located elsewhere in the country. They have this off-campus. I am just referring to the particular relevant definitions. Professional Regulatory Council is there, 2.15. Sponsoring organization means a body being a certifiable or a not-for-profit society of a public trust or company incorporated in Section 8 companies of provincial application upgrading existence deemed to be universities into institute of eminence. There is my lord, 3.0 objectives and institutions of eminence. The objectives of institutions of eminence deemed to universities shall be to provide for higher education leading to excellence and innovations in such branches of knowledge as may be deemed fit and postgraduate, graduate, and research degree level, and award degrees, diplomas, and other academic institutions, distinctions. This is the objective. To engage in areas of specifications to make distinctive contributions to the objectives of the university education system, wherein the academic engagement is clearly distinguishable from programs of an ordinary nature This is distinguishable from programs of an ordinary nature and is turned to developing the capacity of the students and the researchers to compete in the global territory education marketplace.
Mr. Manto, you may not be aware, but there's a pending litigation. I don't know whether it has been disposed of or not between BITS Pilani and the UGC. UGC has dropped the Ministry of Education or the UGC, I forgot, I read it long back, has dropped BITS Pilani from the institution of eminence category. It has been dropped by several years. I forgot. It's out of context.
I'll have to check.
And
I do not
the
know.
reason is, this I read long back. The one or two of the reasons were the number one, the competition is too intense. That's one of the reasons. There are something more. I just forgot. It's a long time I've read it, but it has been dropped from the list of institution of eminence.
If it is so, whether it is still prevailing or it has again.
No,
come
we
back
don't
or
know.
not, we don't know.
I am absolutely out
At
of
that
touch.
time it was there, when this was.
That
there.
time it is there, but recently it has been dropped for several years.
That
I read it long back.
I'm well, glad that was very informed me. I'll check up. If
No,
this
I
is
also
so.
don't remember, but once you are referring to it, it just.
Because, definitely,
mean.
definitely, but there may be, so ups and downs may be there. But
Yeah.
whether it was there in relevant, but the purpose for which it was created. That is, I'm saying they have the right, they have the authority to regulate the courses, innovate courses, grant degrees. UGC said that this need not have to come back to us. They can themselves recognize it, they can themselves go ahead with it. It is there. So objectives. 8.0 also provides for when, how an institution can be declared as eminence, institute of eminence. Then 11, lot of people kindly see. 11.0, then kindly come to 11.2, flexibility in course structure. The institution shall have the freedom to offer courses within a program as well as to offer degree in newer areas after approval of its governing council and subject to broadly conforming to minimum prevailing standards without consulting the commission, but with intimation to it. So, university says that even the commission need not be consulted. Commission need not be consulted without consulting the commission, but with intimation to it. Intimation should be given. And when intimation given, they have granted it. Okay, go ahead. It was in 17, that was, approval was in 2020, post facto approval. The institution of evidence deemed to be university shall also have flexibility of course structure in terms of credit hours and number of years to make a degree after approval of its governing council and subject to broadly conforming to minimum prevailing standards. The institution of eminence deemed to be university shall have complete flexibility in fixing of curriculum and syllabus due to UGC mandated, with no UGC mandated curriculum structure. Just now, my junior has just opened up the UGC website. They have shown number 1 as eminence, Institute of Eminence.
Which year? That is of which year?
2025 it shows.
2021,
25.
25.
Yes.
Showing in the Ministry of Education website.
Ministry of Education website. private institutions of eminence, number 1, Birla, number 2,
Updated in 21.
uh,
Updated in 21.
updated in 21. But then it is 2025, they are continuing it. These are public institutions. In private, it has a Tinta, Manipal and.
I'll show you this. No, maybe because I'm not updated. I read it long back. It just came into my. It just struck me.
Keep track of all this. No, will not. I have not been told. Yes, got
This is 2018. After that, it
No,
will
we
be
don't.
updated.
I told you I'm not aware. I'm not updated.
Lordship, it is said it is updated in 2018, and the one that we have given is in 2021. Lordship.
21. Okay, maybe you are right, Yes.
Otherwise, 2020, UGC ought not to have said so. In 558, 48, it's resolution proceedings. Therefore, my lord, strictly and kindly see.
I'm not following this, but somehow I have a retentive memory. It came back.
Definitely once gone to the mind. Now
Lordship has a
connect-
photographic memory.
No.
We know
It's
that.
not. It's just when Mr. Mantha was repeating that center of eminence, it suddenly
came to your
struck that
mind. So it's still now.
memory is very weak.
And this is.
I don't have a good memory.
No, you done that.
If the bad memory is dislike like this, then.
That is good, man. That is, there lies the beauty. And so in discourse, things come out and it helps to decide.
It's okay. We take your word for it. Then if it's if Ms. Begum has found out it's 21, it's still there. We accept that. We'll take this into consideration.
That's it?
We'll take this into consideration then.
Yes. Another.
No, once it is a center of excellence, then perhaps in this
Notification.
under this gazette notification, you will now come to 11.2. Then you have the freedom of flexibility.
Yes.
This is there.
Yes.
So that's why we told you that once she says it is a center for excellence, we stop there because then everything flows.
And the central government has said at least for employment in central government, that should be required.
That is 234.
334, Lordship may kindly look into. This is a public notice issued by the University Grants Commission.
334, yes, we have already flagged it.
I mean, Lordship, got it, my lord?
We have already flagged it.
Oh, yes. My duty is to point out. my lord. So, it has said, equivalence of degrees, diplomas are decided by the university concerned, not by us. Therefore, now, my lord, going back to section 22 of the UGC Act, though it is not there, but new degrees which are declared to be equivalent by the universities themselves, Commission has given that authority to even excellence, those institutes of excellence. In that case, It is always to be treated. And for employment, central government has already said we are agreeing. I think I can sum up today because one of the
Subject to anything in reply if it comes up.
yes, in reply. One decision.
Yes.
2019 6 SCC 6362.
2019,
6 SCC 362.
name of the parties,
Maharashtra Public Service Commission versus Sandeep Sriram Warade and others. And a few other cases are also there. This is the leading case.
paragraphs,
Paragraph 9.
9.
Yes, this one, photo. The essential qualifications for appointment to a post are for the employer to decide. The employer may prescribe additional or desirable qualifications, including any grant of preference. It is the employer who is best suited to decide the requirement, as candidate must possess according to the need of the employer and the nature of work. The court cannot lay down the conditions of eligibility. Much less can it delve into the issue with regard to desirable qualifications being on a par with the essential eligibility by an interpretative rewriting of the advertisement. Questions of equivalence will also fall outside the domain of the judicial review. If the language of the advertisement and the rules are clear, the court cannot sit in judgment over the same. If there is an ambiguity in the advertisement or it is contrary to any rules or law, the matter has to go back to the appointing authority after appropriate orders to proceed in accordance with law. In no case can the court, in the garb of judicial review, sit in the chair of the appointing authority to decide what is best for the employer and interpret the conditions of the advertisement contrary to the plain language of the same. Therefore, my responsible submission, as I said earlier, advertisement specifically says from a recognized institute. An employer is the best judge. They have utilized my services, they have been utilizing it. When I was the junior engineer, then assistant engineer, then assistant executive engineer, I was appointed after this.
You are still in service.
No, I have retired in
31/12/22.
31/12/22.
31,
12,
22.
22. I have already retired and gone away. Now, because though this honorable court has in the interim order made it clear that his retirement benefits should not be denied to the disadvantage of his condition of service. But they have not paid me because the litigation is there. They are holding back my dues. They are paying me at one grade lower. This is how I am suffering now.
Yes.
Let them say what they want to say. I will come back later on. Deeply.
May it please your lordship. Lord, in this case, UGC was in the, before the honorable single judge, UGC was implemented later on, file our affidavit. And AICT was also implemented and they also filed affidavit. The question of equivalence will come later, Mila. Question of equivalence of a degree will come later. First, it has to be a valid degree. BSc in engineering technology, that degree is unheard of. Maybe it may be offered by any eminent institute or maybe a very big university of grade 1. But this degree is unheard of. That is said by a statutory body of the country. And it has been supported by the AICT. And the situations that has cropped up in this particular matter has been squarely covered up by the judgments of Honorable Supreme Court in Orissa Leaf Corporation. I'll show the paragraphs. My respected senior sir has tried to distinguish it, saying that this judgment is not applicable in case of Bits Pilani, because of the fact that this is a institute of eminent, it's an eminent institute of the country. Their name find a place in that list. I strongly believe this will not alter the legal situation. What my respectful submission would be, my lord, if I can take your lordship to the affidavit filed by, before going to the affidavits, I just would like to point out the legal factum of the whole things. Since the starting of the imparting education through ODL mode, neither UGC nor IGNOU erstwhile has permitted any off-camp UGC has never permitted to establish any off-campus study centers to any university in the country. This may kindly note down. And so far as deemed universities are concerned, like BITS Pilani, the institute which is now under scanner of this honorable court, deemed universities cannot go even beyond their boundaries. Not to speak of to the other cities of the same state or to other state. They cannot go even beyond their boundaries. What they have to do from their own campus only. They are restricted to that only. Therefore, if your lordship can see once for a while, page 202, that is an instrument of that institute only signed by the registrar. If your lordship is taking up 350 mil, writ appeal. ID number so-and-so, name Sunirmal Bhattacharya, admitted first semester 2005-6. Last registered second semester so-and-so. This includes only courses with later grade so-and-so. Degrees are completed. BS Engineering Technology. BS, what I have understood is Bachelor of Science. Pedagogy, this off-campus work integrated learning program structured in accordance with the candidate's qualification and professional experience was conducted with interactive sessions, contact classes, assignments, projects in work environment of the candidate. That means there's in clear terms that there is no classroom training, just like regular courses. So technical courses through ODL mode means open distance learning. In short, we call it distance mode. In ODL mode, technical education was never permitted by any authority. I'll show from the Honorable Supreme Court judgment. Now, if your lordship can come to the affidavit filed by the AICT, that is at 245. Have your lordship got me?
Just a moment.
devotee. Display. His husband to display devotee.
This, instead of 202, we are, we are referring to 275, same document, because we have marked it earlier.
But I'm taking the 350 rate appeal, my lord.
275 is the same document.
So, but may I read from here from one? I'll read from my copy.
It's okay. I'm referring to
Yes,
275 because we have.
Now, my lord,
marked-
in next page, my lord, of this particular affidavit,
Hmm.
paragraph 6, the bottom of the page,
Page 200,
in my copy, it will be 246.
246.
Yeah, in my copy, and lordship copy the next page, my lord. It is an affidavit filed by the AICT.
The ACT is respondent number.
AICT is respondent number 6. Given 246. সেইটো দিলে তো। সেইটো দিলে। Appeal. I believe lordship has got it, madam.
Yes,
Paragraph 6 has your lordship got it.
yes.
May I read now? That with regards to the statement made in paragraph 11 of the writ petition, the present deponent begs to state that the education qualification acquired through the distance mode is not recognized as a degree or diploma. In this regard, there has been a policy of AICT. As per the policy, the qualification acquired through distance mode at diploma, bachelor's, and master's level in the field of engineering, technology, architecture, town planning, pharmacy, so and so, management and catering technology, applied science, and craft were not recognized. And now, my lord, the role of the AICT and the power of AICT to grant technical courses has been upheld by the Honorable Supreme Court in a 2001 judgment, which has been referred in Orissa Leaf Corporation also. I will come to that. Now, if I can take your lordship to the affidavit filed by the UGC. In my copy, it is in page 240, my lord, Annexa 7. In my copy, my lord, it is writ appeal 350.
Page number
240.
240. Yes.
UGC was a respondent number 5. Now, my lord, I will take to the relevant paragraphs only. That paragraph 8, my lord. The UGC was initially not a party to the proceeding. However, fight order dated so and so this honorable court implemented UGC as a party respondent number 5. The query raised by the petitioner whether the degree of Bachelor of Science in Engineering and Technology conferred by Birla Institute of Technology Science situated at Pilani, Rajasthan in the year 2009 is valid or not. This query was raised in connection with the recruitment for the post of Assistant Executive Engineer at IIT Guwahati. It is worthy to mention herein that the Institute of Advanced Studies in Education, Sardar Sir, Rajasthan, is deemed to be university, hereinafter referred to as the institute. UGC has not granted its approval to the university to offer technical courses under open distance learning mode. As per available record, the erstwhile Distance Education Council had granted ex post facto approval, ex post facto institutional recognition to it for the programs approved by the statutory body of the university offered by it through distance mode up to the academic year 2005, void letter dated 29/8/2007. The provisional institutional recognition was also granted to it for the academic year 2007-8, void later dated 3/9/2007 and 11/8/2009, respectively. However, no further recognition was granted to the university either by DEC or by the UGC to the institute to offer any program through distance mode. Be it stated herein that during the period of institutional recognition, the institute was required to programs approved by the statutory bodies of the university and after seeking approval of the concerned regulatory bodies wherever required. This portion is important. My lord, an institution, UGC, as a regulatory body, it approves the institutional establishment of the institute concerned. If particular deemed university is offering a, suppose, MBBS degree, then it needs recognition from the MCI, Medical Council of India. If they are offering engineering degree, then it needs recognition from the AICTE along with the approval from the UGC. Mere approval given by ex post facto approval or approval given by UGC or erstwhile Distance Education Council will not do. And it is the case, it is not a case that DEC has approved anything, anybody or any institute to offer technical degree through distance mode. It has been barred by since 2001. There are notification, and in this particular issues have been
Just a moment. You are submitting that even if a degree is recognized, the first
even
recognition
if course is recognized,
course
course will be recognized, but
so then first it will be the UGC or some regulatory authority
yes, that
And-
that approval subject to the further approval of the AICTE, if it is a
of the
technical-
AICTE.
Yes,
Okay.
it is contingent upon. It is contingent upon the approval given by the concerned regulatory authorities.
Yes.
Next line, my lord, same paragraph. It was the responsibilities of the institute or the university to seek for approval from the respective apex bodies. However, no university or deemed to be university is authorized to offer technical and professional programs, including MPhil and PhD degree through distance mode. It is for information that a deemed to be university can operate only within its own headquarters and campuses approved by the MHRD only. The institute is also a deemed to be university within the meaning of Section 3 of the UGC Act 1956. It is respectfully stated that UGC has not granted its approval to the institute to open any study center in any other state or even within each state. The deemed universities cannot affiliate any college or institution for conducting courses leading to award of its diplomas, degrees, or other qualification. Also, these cannot offer their programs to franchising arrangement with private institutions for the purpose of conducting courses through distance mode. The previous regulator distance education, namely the DEC, under IGNO had accorded ex post facto a program-wise approval to work integrated learning program with effect from 1995 to academic year 2007-8. Fight later dated 24/11/2009 only to Bits Pilani, Rajasthan. The answering respondent on behalf of the UGC begs to submit that the Bachelor of Science in Engineering Technology has never been a specified degree of UGC under Section 22 of the UGC Act 1956. Therefore, they say degrees cannot be treated as a recognized degree. Well, these two things, since it is a technical degree, it cannot be offered through ODL mode. First, their own document says it is an off-campus degree. UGC in clear terms in their affidavit, in this affidavit has said that we have never allowed any university to open any study center or off-campus study centers. We have never allowed. Therefore, any degree obtained through that mode is per se illegal and does not cannot be held to be good. Thus, the question of equivalence does not arise because the degree itself is bad. And one document was my learned senior friend was referring to it, that is a document of at page 308. It is the list of those ex post facto approval, the list of degrees or diplomas which were given ex post facto approval. But
Which-
it's page 308, my lord, 308 and 309, it runs up to 3011, 311. In my respectful submission, my lord, from my learned brother, I have got this. My lord, there is no such degree which has been approved by this. This list does not contain that degree or diploma, which is called Bachelor of Science in Engineering Technology.
Please repeat again. I do not catch
This
it.
list, my lord, from
Yes.
page 308 to 311,
Yes.
these are the degrees and diploma courses, name of degrees and diploma courses, which has been given or which were given ex post facto approval. For a moment, presuming that ex post facto approval is also correct, rightly given. Even then, my lord, this list does not contain that degree. BS Engineering, Bachelor of Science in Engineering Technology.
No, it does. Mr. Mr.
sir.
Mohammed showed us this page to 309. Engineering technology, BS is there, third. So where Rajasthan is concerned, BITS Pilani, third is BS, Bachelor of Science in Engineering Technology, it's there.
No, in
It's
the
covered.
certificate is there.
No. 309 says so. Right side, third bullet. Down below, against BITS Pilani. BS in Engineering Technology.
Oh, yes. It's my mistake, my lord. I did not read the engineering. What is the above the line? I read it technology information system.
No, we've seen that. That's
No,
why
no.
the,
No, it's there.
that's why we asked that question.
I stand corrected. I stand corrected. Now, my lord, if lordship can come to the judgment that I was referring to, that is 2018 1 SSC 468. Orissa Leaf Corporation. Screen বেয়া হৈছে তেতিয়াৰ পৰা কলো চেক কৰিব কাৰণে ওকে মোৰ দুখ নাই আৰু মই আগে কৈছো I'll leave the editorial part, Milad. I'll take your lordship directly to the
Which page?
page 490, paragraph 12. Though in this case, Milad, the subject matter, the only 2 or 3 institutions deemed to be universities were there in this case, but law has been laid down for all. In general, the law had been laid down.
Page 400?
490.
Four nine zero is something we can't read.
No, I'm not referring to the appeal memo, my lord. I'm referring to the judgment. 2018 1 SSC 468. That is Orissa Leaf Corporation.
Acha, not of the paper book.
Not
You
of
are
the
referring to, okay. But who is this respondent number 6? Respondent number 6 is
ACTM.
AICT. Who's appealing for AICT?
Today, my lord, I have seen nobody.
Nobody is there.
Judgment kita dia nahi print ko. Judgment to dia nahi. What possible? মই তাৰমানে দৌৰা-দৌৰি এটা চিটে print কৰি আনিছো।
ইয়াতে কৰিছে।
আছে নেকি? মই আকৌ ইয়াতে প্ৰিপেয়াৰ কৰিলো নহয়, দিগদাৰী হ'ব। নহয়, নহয়। SCC হেৰিটো পেৰাগ্ৰাফটো চেঞ্জ হৈ যায়। ইয়াতে নিজে চেঞ্জ কৰি দিয়ে।
Paragraph?
Paragraph 12, my lord, 490.
Yes.
It may be appropriate at this stage to quote para 19 of the affidavit filed by Mr. Ved Prakash, Chairman UGC. It is pertinent to note that while bringing the 2010 deemed universities regulation to the notice of the general public, including Friday public notice dated 27/6/2013, annexed and accepted later in the instant affidavit, the UGC has also clarified that the UGC has not granted approval to any institution deemed to be university to establish study centers. This is relevant because, firstly, deemed to be university status is concerned on academic programs in specific domains of knowledge. In this case, 4 deemed to be universities were conferred the status to offer programs in the following areas: JRN Rajasthan, Vidyapit, Udaipur, Rajasthan, social work, education, arts and commerce. These are the 4 institutes which were the subject matter of this particular case, but the law that has been laid down is of application of general importance. Here 3 institutions deemed to be universities, namely so and so, UP, overstepped their mandate and started distance education programs, including the award of BE, BTech degrees outside their field of specialization without the UGC and AICTE approval. Secondly, Bhai letter dated 9/8/2001.
Nominal. Please continue.
Citation 2018, 1 SCC 468. Secondly, Bhai letter dated 9/8/2001, UGC has made it clear that franchising of education through private agencies or establishment is not permitted. In addition, UGC, AICTE and DEC have issued a joint letter dated 13/5/2003 annexed to this affidavit to Vice Chancellor, heads of institution, asking them to limit the system program of delivery of distance education of their institution to the neighborhood of the location of their main campus or at the most within the state. And as mentioned earlier, White Public Notice dated so-and-so, UGC has stated that institutions deemed to be universities can operate only within its headquarters or from those off-campus campuses, offshore campuses, which are approved by the Government of India through notification published in the official gazette. Though UGC has not granted approval to any institutions deemed to be universities offered distance education mainly through franchising arrangement and study centers, which are not established with the permission of the UGC. Prima facie, my lord, it's an off-campus degree which was never approved by the UGC or AICTE. Therefore, going further to the issues, in my respectful submission, is unnecessary. Because the very plinth of the argument is this from my honorable senior, that this can be distinguished because of the fact that this is an institute of eminence which finds place in the list of eminent institute, but it cannot alter the legal position. It cannot alter the regulations. Even though it may be an eminent institute, it cannot flout it. Rather, in case of eminent institution, it should be more stringent. Then, my lord, coming to there are some regulations quoted only. If your lordship can come to page 497, paragraph 23.3.
373.
Yes, ma'am. Paragraph four, no, my lord, paragraph 497. Sorry, page 497, paragraph 23.3.
Four 97.
Yes, ma'am. Bottom of the page, 23.3.
No, no. You are reading paragraph of the judgment or
Huh.
the paper book?
No, judgment.
Judgment. Okay.
I'm referring to judgment only.
Paragraph
23.3.
23.3. Yes, we got it.
The AICTE grant of approval for starting new technical institutions, introductions of courses or programs, and approval to intake capacity of seats for courses or programs, regulations were issued in 1994. That is called the 1994 AICTE regulations. Clause 4 of these regulations was to the following effect. Requirement of grant of approval. After the commencement of these regulations, no new technical institutions or university technical departments shall be started, or no course or program shall be introduced by any technical institution, university, including a deemed university or university department or college, or no technical institution, university or deemed university or university department or college shall continue to admit students for degree or diploma courses or programs. No approved intake capacity of seats shall be increased or varied except with the approval of the council. And while AICT has categorically filed an affidavit said we did not approve this course. I believe, Milord, the matter ends here.
Right.
Now, my lord, may I take your lordship to page 515?
Yes.
My lord, Lordship wanted to know whether when DEC, Distance Education Council, was dissolved, that has been mentioned by the Honorable Supreme Court in page 517 of this
Paragraph, give us the paragraph,
30.18.
30.18.
In page 517, it says on 1/5/2013, IGNOU dissolved DEC and regulatory functions of open and distance learning education were taken over by the UGC. Whereafter a notification was issued by the UGC on 17/6/2013. This is just to point out to your Lordship, it may be of any help somewhere.
You're referring to paragraph 30.18.
30.18, page 517.
Yes.
If Lordship can read one just below that paragraph, 30.19. On 27/6/2013, a public notice was issued by the UGC stating that deemed to be universities were not allowed. That means this notification was since before. Were not allowed to take courses in distance education mode. The relevant portion of the public notice was to the following effect. Well, here may be a question that this is a notification of 2013. It's not a notification of 2013. It is just a clarificatory notification. The notifications were in place since 2001. And in this particular point, our division bench, our High Court's division bench has a passage judgment. It's called Ashit Baran Paul. I'll provide the copy of the judgment, madam. Ashit Baran Paul. Writ Appeal 55/2018, if I am not wrong. A deemed university shall operate only within its headquarters or from those offshore campuses which are approved by the Government of India through notification published in the official gazette. There's a clear-cut case, my lord, that to have an off-campus study center, you have to have an approval of the UGC, Government of India, and published in the gazette. Until and unless it is done, any degree obtained through such a franchising mode is not valid, my lord. Lordship, if Lordship is rising for today, then my lord, we can continue in a different day, but tomorrow, my lord, I am out of station, my lord.
You can sum up in 5 minutes, I believe.
Yes, of course. In 5 minutes, I can sum up.
Huh.
Since they have come, I thought Lordship is.
No, that's true, because at 4 o'clock I have a different bench.
Now, my lord, I will quickly take your Lordship to the important paragraphs, my lord. Let me kindly come to page 523, paragraph 34. May I read below? DEC having been dissolved in May 2013, we do not have its stand on record, but the stand of MHRD in its affidavit is to the following effect. Paragraph 7. I further submit that up to year 2007, Distance Education Council used to give recognition to institution offering general courses in the distance mode, but during that year, Distance Education Council also started giving recognition to such institutions to conduct technical programs under the distance mode. This was in contradiction to policy adopted by AICTE, which makes it mandatory to conduct technical programs through the regular conventional mode of education. This created confusion amongst the stakeholders, which gave unfair advantage to unscrupulous institutions conducting such courses in the distance mode. Accordingly, a tripartite committee of UGC, AICTE, and DEC was constituted through an MOU in May 2007 for a limited period of 3 years. In the meantime, on 19 to 2008, a meeting of the Secretary Department of Higher Education, MHRD, was held with the heads of UGC, AICTE, IGNOU, and Joint Secretary to discuss the issue of coordination and maintenance of standards in higher education through distance. In the said meeting, it was inter alia decided that the approval should be granted to the course and not to the institute. However, all those aforesaid arrangements did not live to the expectations. Now, this is the quotation of the affidavit that has been filed by the central government before the Honorable Supreme Court. Now, if I can take your lordship to page 529, paragraph 43. No, 43 is not important, my lord. It's pertaining to that particular case. I'm just reading out the provisions which are of general importance. My lord may take page 535. Two more paragraphs. I will not disturb your lordship.
Give us the paragraph.
Page 49, 535, paragraph 49.
14.
We now move to the second limb of the first questions. Under 1994 AICTE regulation, no courses or programs shall be introduced by any technical institutions, university including a deemed university, or university department or college, except with the approval of the council. Bharatistan declared the said regulation to the extent it required university to have approval for introducing any courses or programs in technical education to be bad. Same thought was amplified in Association of Management of Private Colleges to say that affiliated colleges of the university were entitled to same protection. The question is whether a deemed to be university is also entitled to same protection. The matter can be considered under two categories. The first category could be of a deemed to be university, which was conferred such status for its excellence in a field of technological subject, is now desirous of introducing courses or programs integrally connected with the area in respect of which it was conferred, deemed to be university status. For example, an engineering college which, because of its excellence in the field, was conferred deemed university status, now wishes to introduce courses in subjects like robotics and nanotechnology, which are engineering subjects and integrally connected with its own field of excellence. The second category could be of deemed to be university, which was conferred such status for its excellence in subjects which are completely unrelated to the field in which new courses are sought to be introduced. For example, an institution engaged in teaching fine arts and music for its excellence in that chosen field, or for that matter, an institution engaged in teaching law had been conferred such status. Can such a deemed to be universities claim immunity from regulatory control of AICTE and say that it is entitled as a matter of right to introduce courses in engineering on the strength of the decision of this court in Bharatidasan case that has been delivered in 2001, 8 SCC 676. Now, my lord, in this particular point, my respected senior wanted to make a distinction that since the BITS Pilani is an engineering institute originally, which has been given the status of deemed university because of its excellence, therefore they are protected. But fact remains that the approval of for offering a particular course through distance mode needs an approval from the statutory body, apex statutory body. They are excellent institutes so far as imparting technical education is concerned, is not nobody disputed. But to do something new, which is not permitted in law, they need approval in specific. So imparting technical education through distance mode has never been permitted. That too, operating off-campus study centers. No. So the distinction that my respected senior would like to make was not acceptable in this particular case, my lord, with all respect to him. Now, my lord, last paragraph I would like to show, 542, page number, paragraph 66, 66.1 and 66.2. Accordingly, we direct, this is the operative portion, my lord, of this judgment. The 1994 AICTE regulations do apply to deemed to be universities, and the deemed to be universities in the present matter were not justified in introducing any new courses in technical education without the approval of the AICTE. This is the operating part. I strongly believe, my lord, this cannot be taken away, my lord. And insofar as the candidates enrolled during the academic sessions 2001-2025, the present case of the ex post facto approvals granted by UGC and their authorities concerned are set aside.
Mr.
Division bench item 1 for admission.
Right, please, the lordship.
Yes, you wanted to supplement something more?
My lord. My lord. Basically, my points of argument is that, my lord. Number one, that the LBO report, my lord, it is not incomplete. And no doubt has been created that the petitioner is a foreigner in the LBO report. So, my lord, if doubt is not created, entire proceedings, my lord, vitiated. Number two, my lord, the petitioner specifically taken the plea in her WS that reference is not maintainable and no reasonable grounds were shown and falsely implicated just to harass her. So these are the pleadings in the WS and regarding, my lord, evidence, my lord, linkage. her elder brother was examined as DW2, but in the judgment, her elder brother was examined as DW2, but there is no whisper in the opinion regarding the evidence of DW2. Is not discussed nor considered. So, my lord, the impugned order, my lord, in opinion is prima facie, my lord, illegal and liable to be set aside, my lord. So, my lord, regarding, my lord, LBO report, my lord, I beg to submit some decisions, my lord. Regarding-
None of the decisions you are going to cite will help you. Because this is not not a inquiry initiated by the Superintendent of Police. This is by the Electoral Registration Officer, where we already have a judgment of our court.
My lord,
This is not a, because he's doing his act under the Representation of the People's Act.
my lord, but the Supreme Court referring the Sarbananda Sonowal's case, my lord.
It doesn't refer to the, this. You read that judgment
My
nowhere in that judgment, the LBO report of a ERO is referred to.
My lord.
It's,
What I am going to submit, my lord, that I have given the constitutional rights, all rights, substantive as well as the procedural safeguards, my lord. It is also stated in the Sarbananda Sonowal's case as well as, my lord, in the Abdul Rahim's case, my lord.
even in Abdul Rahim,
My lord,
Abdul Rahim or Rahim Ali,
Rahim Ali, my
in
lord.
that case also the ERO report was never considered. It was not even a
My
matter of
lord, in
consideration
that
for
case, my lord, in that case, it is categorically stated that doubt should be created from which country he has come. And
That's why
then
you're saying you're fundamentally wrong. You're fundamentally wrong because because ERO, that is a revision of,
ERO's report is based on LBO's report.
no.
My lord, kindly another that was discussed elaborately in Anjana Vishwar's case, my lord. May I submit, my lord, Anjana Vishwar's case, my lord.
Yes.
Anjana Vishwar's case, my lord, that is 2023 2 GLT, page 1102. Hey, read to the
2020. 2022 or 2020?
my lord, 2023 2 GLT 1102. Paragraph, my lord, paragraph 35. One, 110. Paragraph 35. My lord, may I read, my lord?
Yes, yes.
Mr. So-and-so submits that in any event, there is a specific mention in the enquiry report that her father resides in Calcutta and that the petitioner was born and brought up in West Bengal, and also there is no indication in the enquiry report that she had come from the specified territory, which is necessary for initiating any proceedings under the foreigners order, tribunal's order 1964 in the state. That, my lord, it is necessary, my lord, to mention from which country he has come. This is necessary. And kindly see, my lord, paragraph 47. Otherwise, my lord, how should be deported after detection? If the country is not known, there is a problem, my lord. Paragraph 47, my lord. We are of the view that the aforesaid submission has to be first addressed inasmuch as if there is no proper enquiry, the subsequent acts, including the reference made and recording before the tribunal, may be vitiated and the opinion of the tribunal may not be sustained. If the foundation goes, the superstructure would collapse. Therefore, if there has been no proper enquiry, nor any allegation, nor tentative finding by the enquiry authority that the petitioner had come from the specified territory within the meaning of Section 6A of the Citizenship Act 1955, it is doubtful whether the subsequent proceedings before the tribunal would be sustained or not. Then, my lord, paragraph 48, second paragraph, my lord. In paragraph, third paragraph.
Just a moment. Point we say. Upper judgment as well. This is the. It will go to. It is not the wrong. Mr. Sharma. In this case, we are finding something very strange. We are sending you this record.
No.
Order sheet at page 4, 8/8/2016.
Heard argument of both sides, also heard AGP for the state DW2 crossed by AGP and discharged, fixing 8, 11, 16 for orders.
Does it appear to be correct? Argument is heard first, then witness is cross-examined.
Lordship.
And then the DW2 was left out.
Yes.
We think in this case, the matter is required to be remanded back to consider the evidence of DW2. And the tribunal will also consider whether DW was cross-examined and discharged first, and then the argument was heard.
Yes, it is.
This is one.
Order is written like that, Lordship.
This is one.
Yeah.
One of the reasons. And second is, Mr. Dey,
Hello.
for this reason, we are desiring to remand the matter back.
Hello.
But insofar as your this ERO is concerned, we have not less than 5 to 10 judgments. 5 to 7 judgments authored by this bench, where we have held that ERO is not covered by any of the decisions. So ERO benefit you will not get. But so far as remand for the purpose of reconsideration of the evidence afresh by considering the evidence of DW2, that is the ground on which we are remanding it back. And they would also consider whether, in this case, the 8/8/2016 order, that argument was heard on both sides. And thereafter DW is cross-examined and discharged. What will be the effect of that in the proceedings? We accept one of your points and we are rejecting the other. ERO will distinguish. Any judgments you want to cite?
Otherwise also, my lord, the procedural safeguards, my lord, this is, I'm arguing for the procedural safeguards.
No, that's okay.
That
but-
the Supreme Court also said there are a substantive safeguard as well as the procedural safeguard is to be provided to the.
That will be there for so far as
My lord.
PW2 is concerned.
My lord.
But your other argument, you can show us n number of judgments, but since you have already decided this issue with a lengthy discussion, we are not accepting that point.
Your lordship's also one judgment, my lord. I have mentioned here, in this line, your lordship has discussed. Then LBO report, if it is nothing, then entire proceedings should be.
No, that is when when the investigation is by the police under the orders of the superintendent of police, not when it is the ERO.
My lord, the ERO directed to the LBO to
Yes.
investigate. Here
Yes.
in this case, my lord,
No,
no
but they are-
investigation has
no,
been
no,
done.
But they are not investigators. These people are not investigators. These people go and verify the facts and come back.
In my case, my lord, they have not visited the spot. Nothing. Without verification, my lord, this format has been submitted and the EROs are created doubt on the basis of the LBO report.
No, you see,
This is the difficulty, my lord. Non-application of mine, totally non-application of mine, my lord.
we can't say that. Whether they have come or not, you could have taken appropriate steps in the trial. You have seen your written statement. Your written statement is at page 39.
My lord. Page 39. Paragraph 1, 2, 3, my lord.
You have taken the plea, but there's no pleading to that effect.
Right.
It's just not there. So on that ground is the only ground where you are remanding.
Yeah, on that ground.
DW2 has not been considered.
Yes, Lordship may
DW2 has not been considered.
consider the evidence of DW2 and Lordship, on the same date, Lordship may, evidence has been taken, Lordship, on the same date, although order has.
We understand, but
Yes, Lordship.
look at the order.
Yes, Lordship, it is not correct, Lordship. And
If you see, this fortifies why the DW2 is not there in the order.
Yes, yes. Lordship. Yes,
Because without considering, he has already heard the matter.
yes, yes, Lordship. It is like that, Lord.
And therefore, in the order, it doesn't find place.
Yes, yes, Lordship. Yes, yes.
Because we both are not finding any other explanation why DW2 is not there.
Yes. Otherwise, if learned tribunal consider the DW2's deposition, Lordship, then also it will, I think, Lordship.
No, but you see, for that, we need only one request from your end. If you make a prayer that we should consider the evidence, then just make a statement, we record it,
Lord.
that the evidence will be examined by us.
No.
We will be very happy.
Lordship. Lordship.
Because you have seen us
Lordship,
reading
Lordship.
evidence.
Yes, Lord. Yes, Lord.
So you just have to tell us. There's something we would love to do. We'll pass the orders. It will be declared. If I can't dictate it today, you are getting it on Monday. Huh? Oh, Monday is holiday, so Tuesday. If I can complete my dictation, I or my sister, we have not decided, we'll do a head till. So whoever dictates the judgment, if you are completing today, then you are getting it on by tomorrow. Otherwise, it goes to Tuesday. We are showing it at disposed of.